Good morning, good afternoon, and good evening. This is Pamela, and you are watching Pam Entertainment TV, where we review movies, television series, and do celebrity legal news. Also, join me for my pop culture chats. If you'd like to support the channel, please like, comment, and subscribe. My Venmo and Cash App is below. Thank you so much, and let's get started.
Hello, y'all. I'm so sorry I'm late. Baby, I got caught up in this doggone Twitter and this Anthony Mackie stuff. You see how I have not gotten all my stuff together. Just craziness. Absolutely craziness. What is going on with my visual effects? Why is it not giving me my background? Child. All right. I'm back. I'm here, and we are going to read these oral arguments. I'm on, y'all. I just had to show y'all. I just giggled at what has got me so tickled, and a couple of other things. But let me see if I can show y'all my screen really quickly. Lord, this is that Anthony Mackie. Because if you weren't familiar, Anthony Mackie had been seen groping as this person right here. Now I think that they are filming. But we we don't know. I personally think that they're feeling, but they if that's what they're doing, they are because it seems like they're overacting because there is sound. Let me see if we can hear it. I don't know if he's not real. We're not gonna go into that because that is not why we are here, child. Let me get rid of this. That's not why we are here. We are here for this reason and this reason only. We are about to get into Can you hear me now? Let me know if you can hear me. Okay, good, good, good. I just had it on the wrong. Thank you so much. I had it on the wrong thing when I came back. All right, cool, cool, cool. I'm excited. Let's read this transcript. And y'all, CJ, because from my last video, CJ is down here in the comments. Please go follow her. She's citizen journalist on Twitter and X, and she's also CJ on YouTube. She is covering this case, and she's also covering the Justin Baldoni and Blake Lively cases as well. And we are in the process of collabing on talking about this particular case as well. So I wanted to catch you all up because, like I told y'all, I had with that Diddy trial, I had neglected this particular case. So I wanted to catch you up on the things that were going on. But she, go look at her in her playlist. She has gone over this case extensively. So make sure that you follow this thing. And I don't have the capabilities right now to put your information in the chat. So CJ, would you do that? Put your information in the chat for the people so that they can follow you. I'd appreciate that, and I know that they would too. This is the one thing that I do enjoy about doing this, because you know how when you're an introvert and you're so isolated that the one thing I like about social media is that you get in contact with other people that like the same things that you like. And, because in your real life, as you walk up and down the street, you may not find these people, but social media does help you with getting attached with people who you otherwise might not have been in contact with, who like the same things that you like. So let's let her put all that information. Let me do this too. There we go. Okay, she put it all down here. Let's see that this is her. I was going to say, this is it. Because I was about to say, you changed it. But this is it on all of her platforms. Y'all go, please, please support her. All right, here we go. So I have the chat down here in the corner because I may not be able to get back and forth to it because this is a long document. So let me see if I can place myself in a different position. Yeah. All right, so that looks good. All right, so here we have the United States District Court, Southern District of New York. Aubrey Drake Graham is the plaintiff versus UMG Recordings Incorporation. They're the defendant. This is an oral argument that was done in New York City on June the 30th, 2025 at 2 p.m. And this was before Jeanette A. Vargas, who is the district judge and who will be presiding over this case, I understand. So who appeared at this hearing was Wilkie Farr and Gallagher LLP, and they're the attorneys for the plaintiff. And then we have Sidley Austin LLP, and they're the attorneys for the defendant. So we have Michael Gottlieb, Brady Sullivan, and Anna Gottfried that we're going to be possibly hearing from in this document for the plaintiffs. And then we also have Roland Ransom, Nicholas Crowell, and Caitlin Everson and James Horner, who are going to be for the defense. And again, I keep saying, y'all see my little friend here? If you hear any roaring, that is my friend, because the fans is going. I don't know why they make it so that all this equipment is so doggone hot, but you got to promote as much air as you can, even with the air that you have at a certain level. All right, let's get into it. So the case was called. And we have Mr. Gottlieb. Now, this is the transcript that I purchased this transcript on Pacer. So let's go ahead and read this information. So this is Mr. Gottlieb, and as I read to you earlier, Mr. Gottlieb is the plaintiff's attorney. Good afternoon, Your Honor. Mike Gottlieb from Wilkie Farr and Gallagher on behalf of plaintiff. With me at council tables are Brady Sullivan and Anna Gottfried. Mr. Ransom, good afternoon, Your Honor. Roland Ransom from Sidley Austin, and on behalf of the defendant UMG. And with me today from Sidley are Nicholas Crowell, Caitlin Everson, and James Horner. The court. Good afternoon, everyone. We are here today to hear oral arguments on defendant UMG's motion to dismiss the complaint filed by Aubrey Graham, popularly known as Drake. So let me outline how I'd like to proceed this afternoon. I love it when the court sets down some rules of engagement. So let's continue. I'm sorry. I love listening and reading transcripts, so I'm really giddy about reading this thing right here. So let me continue. Since this is UMG's motion, they are going to argue first, and then I'll hear from plaintiff's counsel, and then I'll allow UMG to have a rebuttal. For the sake of the court reporter, I will appreciate if counsel would speak at the podium today. I do want to let everyone know that I have reviewed the amended complaint, the documents that were subject of the request for judicial notice, and the parties' memorandum of law. So you should assume in your arguments my familiarity with all of those materials and the arguments of the parties. To preview for you my specific concerns and what it would be most helpful for the court for you to focus on. There are a few issues today that I would predominantly like to hear from the counsel on today. Again, I am loving the fact that she is setting the guidelines. She's not fixing to allow them to just go all over the place. She wants very specific things that they need to focus on because she is very much aware. She has read the information. She needs for them to focus on these things to consider. These are the things that she feels in her mind that she needs to have discussed. The first of those is whether or not I can make a legal determination at this stage in the proceeding as to whether or not the statements challenged as defamatory in Kendrick Lamar's lyric are fact or opinion. Interesting. Second, if it is appropriate for me to resolve that on a motion to dismiss, whether and to what extent I should consider the documents submitted by the defendants in the request for judicial notice in making that determination. And finally, applying the New York Stein-Hilber factors. Are the challenge statements fact or opinion within the meaning of New York defamation law and the New York State Constitution? With that preview of the court's particular concerns, counsel, you may proceed. So she wants to know, number one, whether the statements that are being challenged as defamatory in Kendrick Lamar are fact or opinion. So is Kendrick Lamar stating the fact that this person is a PDF child? Or is he stating an opinion that this person is a PDF file? Is he stating a fact that he believes that Drake is a thing and he has proof to show that Drake is a PDF file? And if it's appropriate to dismiss as to what extent should she consider the documents submitted by the defendants in their request for judicial notice in making that determination? And so she needs to, that's what they need to be focusing on for her. They can go they can go all the way around the world if they want to. She wants them to focus on that argument. So let's consider. Let's keep going. Mr. Ransom says, thank you very much, Your Honor, and thank you for the guidance, which is helpful. I will focus my comments on Drake's defamation claim, although I would like to address the other two claims as well. And I'll focus on our primary argument, which is also the subject of the court's question, which is that the statements at issue constitute non-actionable opinion rather than statement of fact. And to frame it, including in light of the court's question, I want to start with a critical observation, which is that under binding New York law, that issue, the fact versus opinion issue, is a question of law solely for the court. It is solely for the court to decide as an issue of law, which we believe makes it particularly suitable for a determination on a motion to dismiss. And we see, and I will address, a number of cases dismissing claims on this basis. And it is amazing to me that not once in Drake's 27-page brief does Drake acknowledge that this is, in fact, an issue of law for the court, rather than a factual issue to be determined by a jury, the court. Well, let me stop you there, because you are correct that there are a number of cases where courts have decided on this motion to dismiss. The New York Court of Appeals in Bryan is one such case. But then subsequently, following Bryan, the New York Courts of Appeal had Davis versus Boheim, which was in the context of a motion to dismiss and relied quite heavily on the earlier procedural posture of that case in finding or holding that the standard that applies at a motion to dismiss stage was whether or not the communications taken in their ordinary meaning and context are susceptible to a defamatory connotation, and suggested that if they were, and that if they could be taken in such a light, then the motion to dismiss should not be granted and discovery should proceed, which strikes me as being somewhat in tension with the court's prior decision in Bryan, which, as you have observed in your brief, did permit a motion to dismiss because it is an objective standard. It is a reasonable listener standard, a question of law, and applied a somewhat different articulation of the test as to would the reasonable listener have understood the allegedly defamatory comment as opinion versus fact. Interesting. So she's saying, yes, that she is going to rule on this. However, they can take it to the jury if they need to, because they have to determine if whether what was said, a reasonable listener would have assumed that that was a statement of fact or was it opinion. And I think this is why it's important that the whole rap beef be put into context. That them going over every issue be put into context. And so it would behoove UMG to go back to the starting of this beef, because the judge is really and truly going to need the whole full context. Because again, Drake has issued some statements that he can't, that we have decided had, whether or not the public can consider it to be basis on fact or basis that is just assumed to be, fiction. It's just something that we understand that didn't happen. That's coming across. And if you were on my last stream, I explained to you all that Drake is asking UMG to provide information for them to show whether or not that Dave Free is the father of Whitney's baby. They're asking the court to provide information about Kendrick Lamar's, because there was a case back a few years ago where there was some domestic violence issue that happened in a hotel. However, there was no police report. And as I remember the video that was talking about this, it's on YouTube. It was a worker who worked at the hotel who said, and if I remember her, she was saying, there was a person whose name that rhymed with, and she said some word that was supposed to rhymed with Kendrick Lamar, that there was some type of fight that went on in a hotel room, and that the hotel security or whatever it was called, I do not know if there was a police report involved with that. I do not know any of that information. I do know that she said that the hotel security and hotel staff was called to the room. But like I said, I don't know if there's a police report to follow it. I don't know if they'll be able to get in contact with those workers. They definitely can get in contact with the hotel. I'm quite sure that there is footage, or at least going outside, footage of that. But Kendrick Lamar did go on the Breakfast Club, and he said that that was not the truth. So we will see what happens on that. But anyway, let's continue. Mr. Ransom says, of course, Your Honor, two things about Davis versus Boheim. The first, including the way the court characterized it, the issue of whether a particular statement is acceptable to defamatory connotation is a distinct element of the defamation claim from the question of whether it is fact or opinion. And I recognize that on that issue. Whether a statement is acceptable to a defamatory connotation, there are cases that suggest that there's a dispute as to whether statements could have a defamatory connotation or not might go to the jury. That is treated distinctly from the fact versus opinion. And in fact, we see that distinction in Goldfarb, the case that Drake primarily relies upon, and which, as we pointed out in our reply, they misapprehend on this point because the court considers separately and distinctly the question of defamatory connotation on the one hand and fact versus opinion on the other hand. And as to the fact versus opinion, the court expressly notes that this is a pure question of law. The second observation, and then the judge interrupts and says, that is true. But I do not want to press back on your reading of Davis, because Davis also does consider the opinion versus fact distinction and says that they cannot state as a matter of law that the statements are pure opinion because there's a reasonable view of the claims that have been asserted in the complaint, and that the court has to take that reasonable view in favor of the plaintiffs at the motion to dismiss stage, and therefore decides not to dismiss it. So although, yes, they also discuss the defamatory context, there is a portion of that opinion that is focused on the opinion versus fact distinction, which is the one raised by the defendants in this motion. So Mr. Ransom comes back in and he says, and I do think in that respect, there's a slight conflation even in Davis. That said, Davis continues to apply the Stein-Hilber test, including the consideration of the four sometimes collapsed as three elements of determining fact versus opinion. And I think what's ultimately critical about Davis gets the court's final question of those that it laid out, which is this fact versus opinion? And what was critical in Davis was the court's ultimate conclusion that the nature of the statements in Davis strongly suggested that the speaker had undisclosed information underlying his statements that would lead a person to conclude that they were statements of fact. And as you walk through the ultimate conclusion of Davis in determining that it survived a motion to dismiss on the fact versus opinion issue, it was ultimately driven, I submit, in its entirety by the court's conclusion that there were multiple factors that would lead a listener to believe that the speaker there had undisclosed information unique to him that led him to make the statements that he did. That including his reference to the fact that there was an investigation at the university underlying his conclusion, that his statements came out before the results of that investigation were released, and that he held a position of authority at the university about which he could speak with authority and solemnity, and that the nature of his comments presented for an article and discourse on the issues were such that they were not rhetorical hyperbole, but they were not in extremis or other consequences that led one to conclude that they are likely to be statements of opinion. So that was the ultimate conclusion reached by the court, and we have none of that here. None of the context, none of the indica that suggest a thoughtful statement of fact based upon some weighty investigation as to which the speaker is privileged. And I will address that in greater detail, but I think it's critical, even under Davis, which continues to articulate and apply the Stein-Hilber factors, to emphasize the context is key. In Stein-Hilber, here are the words. Even apparent statements of fact may assume the characteristics of statements of opinion when made in public debate, heated labor dispute, or circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. And Stein-Hilber was 40 years before its time. Epithets, fiery rhetoric, or hyperbole. It might as well have said statements in a rap battle. Because, when you listen to rap and all those things, there are entendres, there are hyperboles, there are synonyms, there's similes, there's all of these things. And even some rappers have the ability to rap in a haiku. So There's a whole lot of stuff going on in these rap battles, which is why rap battles are not for the weak. And what I mean is which is why rap battles, if you come from my community, basically these rap battles is like, I don't know what they're called and what sections of the country that you come from, but some people call it jonesing, some people call it shooting a dozen, some people call it any and other kinds of things. If you know what you call it in your area of the United States, y'all put it down in the comments. But again, basically, all these things too. Because even the way that I am considering all of this, and this right here is my opinion, and you see it going across down the line, but I forgot to put that up as a image file up here. Let me do that real quick, because we got caught up in all of this. I started because I'm so giddy. But y'all know the views and opinions expressed in my videos represent my own thoughts, concerns, and analysis. I do not know these entities or persons personally, and my opinions are just that, are not a statement of fact. I need y'all to understand that and understand that clearly, because some people think that sometimes when you say these things, and with all these lawsuits that are flying with these content creators, I do not want anybody to misconstrue me, because don't come at me. Don't come for me, because I'm not coming for y'all. I am just reading what I am reading. And I am reading what I am reading. And while I am reading what I am reading, let me go ahead and put my copyright disclaimer on the Section 107 of the Copyright Act of 1976. Allowance is made for the fair use for the purposes of such as criticism, comments, news reporting, teaching, scholarship, education, and research. Fair use is a use permitted by copyright statute that might be otherwise infringing. We will continue to go over this lawsuit, and let me figure out where I was. Here we are. And even Steinhilber and the subsequent cases, including Davis, as an exemplified and in Davis, recognize that contextual assessment of the content in which the statements are made often ultimately determines whether one would perceive these as fact versus opinion. And that's what was found in Davis, because of the context in which those statements were made. And on the other hand, in Steinhilber, because of the context of the statements were made in Steinhilber, the court affirmed a motion to dismissing the complaint as a matter of law, concluding that although the statements may be perceived as factual, the context in which they were made would lead a reasonable observer to conclude that they were pure opinion, including because of the heated nature of the communication. All right, here are the lyrics. All right, so I'm going to read that first verse. Mustard on the beat, ho. Debo, any rap ninja, he a free throw. Man down, call a amber lamps, tell him breathe, bro. Nail a N-word to the cross, he walk around like Tizo. What's up with these jabroni ass N-words trying to see Compton? The industry can hate me, F them all and their mama. How many ops you really got? I mean, it's too many options. I'm finna pass on this body, I'm John Stockton. Then he says, beat your ass and hide the Bible if God watching. Sometimes you gotta pop out and show N-words. Certified boogeyman, I'm the one that upped the score with him. Walk him down whole time, I know he got some hoe in him. Pole on him, extort S. Bully death row on him. Say, Drake, I hear you like him young. You better not ever go to cell block 1. To any B that talks to him and they in love, just make sure you hide your little sister from him. They tell me Chubb's the only one that gets your hand-me-down. And parties at the party playing with this no now, because you listen to the wording that he says. Go back up here. He says, say, Drake, I hear you like him young. Now, if you're familiar with this rap battle in Tailor-Made Freestyle, and I guess we're going to have to go over those lyrics in Tailor-Made Freestyle, Drake tells him about that angle. So say, Drake, I hear you like him young. You better not ever go to cell block 1. Why? Because it is common knowledge that when PDF files or people who mess with kids go to jail, prisoners, they don't take, they you know, the one offense that they never take kindly of is that type of offense. It says, say, Drake, I hear you like him young. You better not ever go to cell block 1. And then he says to any B that talks to him and they in love, just make sure you hide your little sister woman. He says, they tell me Chubb's the only one that gets your hand-me-down. And say that and connects that they tell me and party at the party playing with his nose down. And that goes back up here to the they tell me. Who is they? Who is the proverbial they? And Baca got a weird case. Why is he around? Certified lover boy? Certified PDF files. Now that's in plural. Because they, if you understand, again, if you go back and you do the research about Baca and his weird case, it had something to do with him beating up a girlfriend and also some hints of trafficking. However, the trafficking charge was dropped, but he pled, I think he pled guilty to beating up the girlfriend, and he went to jail for that because he had other cases that he was found guilty of, or some other pending cases. But anyway, on this guilty verdict, he did have to spend time in jail. So it says, wop, 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 dot F them up, wop, 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 I'ma do my stuff. Why you trolling like a bee? Ain't you tired? Trying to strike a chord, and it's probably A minor. Sorry. So we got the chorus of they not like us, they not like us. Then we have the second verse. It says, you think the Bay gonna let you disrespect Pac? I think, not I know, for sure, I think, I believe. Those are not statements of fact. Those are just, I think that it might happen. I think that Oakland show gonna be your last stop. Did Cole foul? I don't know why you still pretending. What's the hour? Bird ninjas and burnt bees. Go. He says, the audience is not dumb. Shape the stories how you want. Hey, Drake, they're not slow. What stories are they talking about shaping? This is interesting to me. Rabbit hole is still deep. I can go further, I promise. Ain't that something? B-Rad stands for B, and you Malibu's most wanted. What is the audience not dumb about? What stories is he trying to shape? What is he talking to Drake about? I'm quite sure that Genius has their thing, but let's what is the audience not dumb about? It says, ain't no law boy, you ball boy, fetch Gatorade or something. Since 2009, I had this thing jumping. You N-words get a wedgie, be flipping over your boxers. What's OVO for? The other vaginal option, pussy. N-words better straighten up their posture. Got famous all up in Compton. Might write this for the doctorate. Tell the pop star quit hiding. F a caption, want action, no accident. I didn't read that right because it's hard trying to read something and you hear yourself singing it in your head at the same time, and I don't want to sing it. because you know how these copyright things go, child. And I'm hands on. I'm hands on. He effed around and got polished. Now, let's go down to here. So all of that means something. They're going to talk about that. So then he says, you effed on Wayne girls while he was in jail. That's conniving. Then got his face tattooed like a bee, apologizing. That's a true statement. Drake had the tattoo because I think he had a tattoo of Wayne, LeBron, and there's somebody else that he's got tattooed on his body. He says, I'm glad D Rose came home. Y'all did not deserve him neither. From Alondra down to Central, those are streets in Compton. Better not speak on Serena, because Serena is also from Compton. And your homeboy needs subpoena. That predator moves in flocks. Now, he never says who the homeboy is, but he says that predator moves in flocks. That name got to be registered and placed on neighborhood watch. He says, I lean on you inwards like another line of walk. Yeah, it's all eyes on me, and I'm going to send it up to Pac. He says, put the wrong label on me, I'm going to get him dropped. He says, sweet chin music, and I won't pass the op. How many stocks do I really have in stock? He says, 1, 2, 3, 4, 5 plus 5. The devil is a lie. He is 69 God. Freaky ass N-words need to say they ass inside. Roll them up like a fresh pack of za. The city ass back up. It's a must because we outside. Goes back into the chorus. And this is the one that I think, this is the one that I think messed him up. But if we're going to go back up here, one of the things he said, and your homeboy needs a subpoena. Who is that homeboy? And your homeboy needs a subpoena. Who is the homeboy? He says, put the wrong label on me and I'm going to get him dropped. Sweet chin music and they won't pass the ox. So I'll stop there and let's continue back into what we're talking about over here. So the court says, since you bring up this context, isn't the logical import of your argument that statements made in either a rap battle or diss track, therefore are categorically opinion? Isn't that the logical conclusion of what you are saying? And is that a fair reading of New York case law that where the New York courts have said forum is not necessarily dispositive? But it does seem to me that you are arguing that forum here is dispositive. A rap diss track just can't be taken as fact. And Mr. Ransom says, Your Honor, the cases that say form is not dispositive, I do not dispute that proposition as a general proposition. It is typically raised in the context, for example, of an op-ed page or a letter to the editor, where the context would tend to suggest one of opinion, but the court said that it's not dispositive. And I suppose in those circumstances that it's theoretically impossible that the nature of the communication, even in which it is otherwise thought to be an advocacy piece with heated rhetoric, may support a finding of fact versus opinion. Whether a diss track in a rap battle could ever cross the line from opinion into facts is an interesting question. I would submit that the nature of the art is that is at most highly unlikely and may categorically be the case that it doesn't. But what we're dealing with are the facts in the case here. And what we can see and what we can look at on the facts here is the nature of the lyrics clearly convey the sort of rhetorical hyperbole, over the top trash talking extremists that, using the language of the Court of Appeal in New York and the federal courts applying it here in the Southern District of New York, are clear, and we submit the positive indicia, I think I'm saying that right, of rhetorical hyperbole and opinion rather than fact. And you can see that more pointedly in cases that are closer to this than those that offer the reservation about the form in which the statement is made. So in Hobbs versus Imus. Now, if this is hold on. All right, so I had to go back to see what Hobbs versus Imus was about. And it says here the case Hobbs versus Imus, also known as involved a defamation lawsuit against radio host Don Imus and Bernard McCurk. The plaintiff, Hobbs, alleged that the statements made about him on Imus's radio show were defamatory. The New York Supreme Court Appellate Division ultimately affirmed the dismissal of the case, finding that the statements made within the context of a shock jock talk radio show would not be reasonably interpreted as factual pronouncements, but rather as opinionated and hyperbolic expressions of the host's views. So they said the allegation was that, and let me show this tab so y'all know what I'm reading. Hobbs made the claim that radio hosts made defamatory statements about him. The context, the show was known for its provocative and often crude style, which the court considered when evaluating the statements. And this right here is going to be key in this case, because they have to put, the judge, I'm hoping, has to see it in the context of a rap beef. And so they're going to have to go back and pull out all of, if UMG's team is going to have to pull out the famous rap beefs. Hit 'Em Up by Tupac is a great one, because he came off the bat. F your B and the click you claim. Then he says, that's why I F your wife. Now we know that Faith has come out and said that that wasn't the truth. That didn't happen. She was in the industry and they were working on music, but she never had intimate relationships of the physical kind with Tupac. However, that was just inflammatory so that for us to sit back and to listen like this. But the context of this rap beat is important, because I have told you all before, the way Drake is setting this up, he's making it seem like Not Like Us came out of nowhere. And that he makes it seem like Kendrick Lamar got up one day and just put this out here without any context of anything. He is making it seem like it just came out of nowhere, and he's trying to pull out the context. And UMG has to come back and place it back in the context of what this is. And they have the ruling that the court found that the statements to be non-actionable opinion. So that's where we're getting this wording, the non-actionable opinion, not factual claims, and therefore not defamatory according to Find Law. It says the Court applied the legal principle that statements made in the context of a, quote, shock talk radio, known for its hyperbolic and opinionated nature, are generally not considered to be factual statements and therefore not grounds for a defamation lawsuit. So we also have people who are filing amicus briefs that are talking about rap and stuff like that. So hopefully they will be able to pull in more context, or maybe UMG can pull them in to have more context of what a rap beef consists of, because we have considerable amount of rap beefs. that we can go back to? Because I'm trying to think. The earliest rap beef that I remember, wasn't it LL Cool J against Cool Mo D? That's the earliest rap beef that I can remember. And then I remember LL Cool J had an issue with, I think it was it Cannabis? I don't think it was Cameron. I think it was Cannabis. And then you got into Nas and Jay-Z. Then you got into Biggie and Tupac. And there have been other rap beefs that have gone on that they can pull up. Interesting. So, in Hobbs versus Imus, for example, again affirming the grant of a motion to dismiss, the court relies on the fact that these are shock jocks, and it's not just the limited statement in which the alleged defamatory communications are made. The court relies upon their notorious history and the nature of shock jock journalism from these speakers, and particularly as supporting its conclusion. On a motion to dismiss, that the context tells you that these are statements of opinions, and it acknowledges that if you just look at the statements taken in isolation, one could argue that they have an indicia. I'm thinking that's right how to pronounce it. Let's see. Indicia of fact, but when you look at the shock jock's context, the court ultimately concludes the claims must be dismissed. And then they talk about in Rappaport. And he didn't finish because the court says, again, let me press you on this. The context here is that the rap diss battle, and we're here on a motion to dismiss. When I'm considering this concept, I need to know more about whether the ordinary listener of, and maybe there's a question as to who the ordinary listener, who is the ordinary listener. And that is key because, again, I think, I don't know if I said it at the beginning of this video or if I talked about it in the video that I just did. You have to look at who is the audience that they're targeting. And I made very specific that the audience that was being targeted in regards to fan base, and usually Drake's fan base at the height of his career has been women between the ages of 18 and 45, particularly college attending women. Also, who's been his fan base has also been men between, at the height of his thing, between 25 and 45. Now, as this rap beef has come up, I've seen more younger men being part of this situation. And again, that has to do with the streaming community, and the streaming community, particularly on Twitch and any other platform that they have, that those people have come up within all of that. So who is the audience? Who is their audience? That is who their audience is. Also, if you look at Kendrick Lamar's audience is mostly Black men between the ages of 25 and 55. He does have a huge audience of white males between that same age group. And he also has a high demographic of Black women between 18 and 45. I am not sure his fan base between women between 25 and up. But I know that the first three is particularly his target audience. So all of those people combined would be considered as the ordinary listener. Okay? So I need for us to understand that ordinary listeners, these are the people who are buying and listening to the information, not Farmer John in Indiana. He possibly wouldn't be listening to rap music. But the people who are listening to rap music is the people who UMG is going to have to say is their ordinary listener. Okay? It is someone who does not follow. Is it someone who does not follow rap music and is just hearing it on the radio? Is it someone who is actually immersed in the community and that the type of music has that background? Those are questions that we could discuss. But with respect to the context on the motion to dismiss, how can I say that the ordinary listener would, comparing this now to the shock jocks? Shock jocks say shocking things. How do I, sitting here as a judge, know that the ordinary listener of a rap diss track would have that same underlying assumption? Isn't it true, for example, that sometimes accusations are made in rap battles that are true and turn out to be true? I don't understand that. And maybe listeners have that understanding. And sitting here as a matter of law, can I say that they would not? Do I need to have more discovery, potentially experts, potentially more context for this particular rap battle or rap battles writ large before I can make such a judgment as a matter of law? And that right there, people, this whole paragraph that she's saying is why I think that she's going to rule for this to go to court. Because she is going to have to know that a listener, and she's got to hear from experts. She's going to have to hear from people who have been in the rap game for so long, talking about a rap beef and a battle. So let's continue. Mr. Ransom speaking now. There is no suggestion of any of these cases that this is the subject of, for example, expert testimony or otherwise. What the court is required to do under the standard, as articulated in both the New York State and federal cases, is to look at the material before it and reach that determination based on its evaluation of the statements and the surrounding context. And we can again look to an example in Terrain versus Liu. And in Terrain versus Liu, again, resolved a motion to dismiss. The court did take into account the context. And I do want to address the court's question about whether it can look at this material at this stage, because I think Terrain is particularly probative of that point. All right. So it says here, let me show you. So it says here, on appeal, Terrain argues that the district court improperly concluded that Liu's various statements that Terrain was a, quote, sick, racist PDF file, a loser PDF file, a broadcaster PDF file, and a child predator, a lunatic, and that he must be put behind bars and should be terminated from the face of the earth. Let's go here. So this man said all of this stuff, and according to, let you all see this tab, he said all of this stuff. They were opinions and not statements of fact. Even though they were inflammatory, they were opinions and not statements of fact. Under New York and federal law, expression of pure opinion as opposed to statement of facts are not actionable, receiving full Constitution protections. A mess. And again, this looks like it had something to do with the shock job. Let's continue. So while we're here, we're talking about that. So let's really get back to the second part so that way I can go ahead and close this out. Let's get into the third verse of the lyrics. It says, once upon a time, all of us was in chains. Homie still doubled down, calling us some slaves. Atlanta was the Mecca, building roads and trains. Bear with me for a second. Let me put y'all on game. Settlers were using town folks to make them richer. Fast forward 2024, you got the same agenda. You run to Atlanta when you need a check balance. Let me break it down for you. This is the real N-word challenge. You called Future when you didn't see the club. Little Baby helped you get your lingo up. 21 gave you false street cred. Thug made you feel like a slime in your head. Quavo says you could be from North Side. 2 Chainz says you good, but he lied. He says, let me get back up here. You run to Atlanta when you need a few dollars. No, you're not a colleague. You're an effing colonizer. Then he says the family matter, and the truth of the matter, it was God planned to show y'all the liar. And then the bridge is, he's a fan, 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 he's a freaky ass N-word, he's a 69 God, and they go back. Then they say, hey, 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 run for your life. Repeat that. Then he says, let me hear you say OB ho. And then they say step this way and step that way. And that's the end of the song. So, and the outro is, are you my friend? Are we locked in? Then step this way and step that way. So this is the song that Drake is saying that defamed him. He's saying that because he's made these statements, Drake's reputation has been tarnished. But again, I put you on game of the wording that was used. Because he said something in his statement of opinions. He says, say, I hear. Not that I know, but I hear you like me. So let's continue. We'll probably have to go back to Family Matters and some other verses and things like that. But let's continue to see what they're saying. Where are we? We're on page 12. We're doing pretty good. All right. But the courts look at the information and makes an assessment on its own. It did the same thing in Rappaport. Now, admittedly, Rappaport was a summary judgment motion, but it illustrates the nature of the information the court is to consider in reaching that determination, which is the language used and the broader context in which it's provided. That's the universe of the material it looks at. And then it comes to a judgment. And then the judge says this. And let me tell y'all one thing. I love an interactive judge. I love a judge that comes in and says what they need to say. The court says, but if the broader context, which is what we're talking about, is perhaps a specialized world, then perhaps the court does need more information that is in the four corners of the complaint. And even in the request for judicial notice, to understand that context and correctly apply the legal test. Do I have enough facts about that broader context to come to a decision about what's a reasonable listener would conclude, whether or not the statements made in the song are to be taken as fact of opinion? And Mr. Ransom says, again, Your Honor, again, what the cases do look strictly at the materials that's presented, including the context that's provided. You do have additional information, certainly, in the form of the amicus brief that was provided in support of our motion, but also from the complaint itself. And what is interesting and notable in the case is that the complaint not only includes the allegation, but it cites and references, excuse me, the fact of the rap battle, articles describing the rap battle, articles describing the context of the rap battle, and the history between these particular artists, including the rumors, innuendos, and controversies that have surrounded Drake with respect to his relations with underage women for an extended period of time. The context is provided. There's no suggestion in case law that the court needs to limit itself to a particular type of individual, a particular type of listener, or that every listener has perfect knowledge of all the information surrounding it. That would turn an objective test into a subjective test that's dependent on individual particular listeners with very specific information, and none of the cases suggest that is required. In fact, All of the cases that talk about this issue posit that the information is generally available and considers with that information that is available, what would the objective listener reasonably understand? And on the question of what the court may consider and evaluate, again, we look at terrain in particular. Here's a case where the speaker made a statement and the plaintiff disputed whether or not the court could consider the surrounding context, including earlier statements by the plaintiff that prompted the defendant to make the challenged remark. In footnote 1 of the circuit opinion, it also, in footnote 1 of the district court's opinion, the court says, Terrain, the plaintiff, contends the district court improperly considered the statement that he made during his war of words because they were not included in his complaint. That argument fails. As noted, in determining whether a statement is actionable, the court should look at the overall context in which the assertions were made and determine on that basis whether the reasonable listener would have believed that the challenge statements were conveying facts about the libeled plaintiff. Terrain himself introduced this context in his complaint, noting that he was engaged in a war of words with a rival disc jockey. That's exactly what we have here. Drake's complaint identifies the rap beef, identifies a number of the tracks in the rap beef, then cites countless articles describing and discussing the rap beef in all of its context. And all of that is properly before the court and may be properly considered by the court in connection with a motion to dismiss. And I think what's critical is that it includes, for example, Drake's own statements in tailor-made freestyle. Woo! Hold on, y'all. Hold on. All right, here we go. In which he specifically said and prompted to Kendrick Lamar, referring to himself in the third person, talk about him liking young girls. That's a gift from me. So when Kendrick Lamar then raps, hey Drake, he said to say Drake, I hear you like him young. There's no secret or surprise or mystery of the context in which that statement is made. Again, these lyrics, this context is all properly before the court, including because of the way the complaint is pled and the abundance of references not only to the lyrics themselves and the beef itself, but also to the articles that provide the context to the court that allow it to make the determination it needs. All right. So now we're going back and we are reviewing the lyrics of Tailor-Made Freestyle. And this is the second diss track from the Toronto rapper and his beef with Compton rapper Kendrick Lamar. Now, this is the song that he uses the AI. And this is the song that the state of Tupac had taken down because of the fact that he was using Tupac's voice. And so we're just going to go over the verse that to give you all as much context as we can about this tailor-made freestyle. So let me give you the verse. It says here, Kendrick, we need you. And he's using Tupac's voice. Kendrick, we need you, the West Coast savior, engraving your name in some hip hop history. If you deal with this viciously, you seem a little nervous about all the publicity. It says, F this Canadian light skin dot We need a no debated West Coast victory, man. Call him call him a B for me. Talk about him liking young girls. That's a gift from me. Heard it on the Budden podcast, so it's got to be true. They told me the spirit of Machiavelli is alive in a N-word under 5'5", so it's got to be you. I would beat the whole effing game. It was me and Snoop Dogg had my effing shirt off in the House of Blues. Now, if you're unfamiliar, in the House of Blues, you had Snoop Dogg and a whole bunch of West Coast rappers that kind of crowned Kendrick as the next big thing. So that's what they're talking about within the House of Blues. Okay, you got to F this inward girl. He got to get abused. All that S about burning tattoos, he's not amused. That's jail talk for real thugs. You got to be you. And so in this whole situation, let me finish it. Got to leave this MFer broken and bruised before we all really lose. You asked for the smoke. Now it seems you too busy for the smoke. I won't lie, the people confused. Now you about to give this S another week and fall back so homegirl can run her numbers up. I would refuse All right. So I'll be back. Real quickly in the chat, can you hear me? Can you hear me? let me know real quickly. I had to change my all I need is one person to let me know they can hear me before I continue. I used a new setting. Use my new mic, and I want to make sure that you all hear me. So would somebody, just one person, let me know down in the comments that they can hear me. So I've got 20 something people on X and a person from Twitch. So would one of you all just let me know real quick? You don't have to put but one letter, just so that I know that you all can hear me. Can you hear me? Can you hear me? Okay, I did a test. I can hear me on my, and I did it on my phone. So we are going to continue. So we're listening to the plaintiffs. This is Drake's attorney, and they're going to be putting down their argument. So it says, Mr. Gottlieb says, yes, Your Honor. Your Honor, I'd like to start, if I could, with a discussion about the appropriate standards of review, because I think it cuts across all of UMG's arguments in this case, and it is important to have a reminder, both from the federal standard and the state standard, of why we're here today. Under the binding Second Circuit authority, the global network communications case that we cite in our papers, a complaint may not be dismissed pursuant to Rule 12b-6 unless it appears beyond doubt, even when the complaint is liberally construed, and that the plaintiff can prove no set of facts in support of his claims which would entitle him to relief. Davis versus Boheim is the only opinion doctrine case cited by either of the parties in this case that remotely touches on the appropriate standards of review at the pleading context for evaluating an opinion defense, and is utterly devastating to UMG's entire argument in this case. Let's see why it's devastating. As we explained on pages 1 and 7 of our brief, the question on a Rule 12 motion, which, considering an opinion doctrine defense, is not what this court thinks or what Mr. Ransom thinks a reasonable listener should have concluded when it heard the lyrics in question. The question is whether a reasonable listener could have concluded that the statements were conveying fact about the plaintiff. Davis versus Boheim is the controlling authority. There is no other case that either party cited that even purports to interpret the standard at the pleading stage. At page 268 of the opinion, the Davis court explained that at the pleading stage, we, quote, limit our inquiry to the legal sufficiency of the plaintiff's claim without evaluating the sufficiency of the party's evidence, as would happen at the summary judgment phase. Davis expressly argues in this case that the court should reject the plaintiff's interpretation that were contained in the allegation in the complaint, and instead hold using objective standards, which we don't dispute applies. That the reasonable reader would be likely to interpret this statement as pure opinion. The court rejects that and
This is the most important part of the opinion. The court says, and we quote, on a motion to dismiss, we consider whether any reading of the complaint supports the defamation claim. Thus, although it may well be that the challenge statements are subject to defendant's interpretation, the motion to dismiss must be denied if the communication at issue, taking the words in the ordinary meaning and context, is also susceptible to a defamatory connotation. Meaning, if it's susceptible to a connotation that is fact and that is susceptible to a connotation that is opinion, the plaintiff wins at the motion to dismiss stage. Court. As I asked Mr. Ransom earlier, though, how do I square that with other courts of appeals decision, including Bryan, which was also a motion to dismiss decision and which they do not purport to overrule, so therefore remains good law. Still cited by New York courts, but did not use this could standard and did not say is susceptible to a defamatory connotation, but says instead, the question is whether or not it would be understood by a listener as opinion or fact and presents it as a question of law. Mr. Gottlieb, so your honor, the court. So she didn't let him interrupt her. Says, I take you that Davis definitely throws a wrench in the argument, but there seems to be some tension. How do I reconcile that tension? Mr. Gottlieb, so your honor, I don't think that there's tension. So first of all, Davis is the subsequent and most recent opinion, so it would be controlling for this purpose. The Bryan court does not purport to interpret the pleading standard. So there's no dispute between the parties as to what the court's inquiry ought to be in evaluating the pleading on its own point, on this one point. The second is that there's no discussion or suggestion in the Bryan opinion anywhere that there was a challenge to the actual content of the allegations on the complaint, which is what we had in Davis and is what we have here, where you have the defendants essentially saying, don't credit or believe or draw inferences from the allegations in the complaint in the plaintiff's favor. Instead, accept this other evidence that we're presenting to you and draw inferences in order to determine what the appropriate social context is so that you can make your decision as a matter of law. In Bryan, the only thing that the court considers, at least from what one can tell from reading the opinion, is the four corners of the op-ed that's being considered. The court was merely analyzing an op-ed and talking generally about what op-eds are. There's no suggestion in Bryan that there was an attempt to insert intrinsic evidence into the record. There's no suggestion that there was any challenge to the inference that the plaintiff was being asked to draw of the complaint. And the Bryan court makes it clear that in the text of the article itself, the author made it clear that the purpose of the article was to advocate for an independent investigation. And in support of that argument, the defendant marshaled all of the relevant materials, including within the text of the article. So the court had basically anything it needed in order to analyze both whether it was capable of a defamatory meaning, whether it could be proven true or false, and what the context immediately of the article in the broader social context were. There's simply no indication that there was any dispute before the court as to any of that. In this case, what we have by contrast is an express request for judicial notice that I want to address before I get into the sufficiency of our allegations, if I could. That request for judicial notice asked the court to accept 17 exhibits into record and to use evidence contained in the exhibits to draw inference that directly attack, contradict, or undermine the allegations in Drake's complaint. Now, there's a time and place for the weighing of evidence, but that is either at trial or at the Rule 56 stage. It is not here. And UMG has no answer whatsoever to the binding Second Circuit authority that we cite at page 14 of our brief, which is the Global Network Communications case, in which the Second Court makes it clear that the conversion requirement of Rule 12b is mandatory, not discretionary. And under that rule, and the court interrupts, Rule 201 allows me to take judicial notice at any stage of the proceeding. That's explicit in the rule. And certainly, ample cases take judicial notice on the context of a motion to dismiss. That doesn't convert it to a summary judgment motion. By definition, it doesn't. Because I am permitted to consider both materials within the four corners of the complaint, matters that are incorporated by reference or that is integral to the complaint, the facts are judicially noticed through Rule 201. And if I do, then that doesn't convert it to a summary judgment. And Mr. Gottlieb says, well, that's correct, Your Honor. We do not dispute that. What we dispute is UMG's suggestion that the court can either use the materials for either the truth or the matter asserted, which they're disclaiming here, but also can use the materials to make factual inferences based on the content of what the court finds within those exhibits, the court. Well, let's talk about the song lyrics in the rap battle. There's an argument that they are already incorporated by references, except perhaps one, the tailor-made freestyle, which was notably omitted in the amended complaint by reference, but the other songs in the rap battle are referenced and linked to their Spotify, or I think it was their Spotify listing. So am I not even sure that I need to take judicial reference that they are not incorporated by reference in the complaint, but certainly there can't be dispute about what the lyrics are. The lyrics are what they are. Interesting. So he put out all that other information, but he did not put out the tailor-made freestyle. Wait a minute, Drake, what you doing? The judge don't have the tailor-made freestyle lyrics? So to make this easy, we don't challenge that the court can take notice of the fact that lyrics exist in a song out in the world. Isn't that interesting? That's a whole song that Drake did to bait Kendrick into this rap battle. Because you remember, Like That was a throwaway. He had no intentions of going into a rap battle. He just said, F the big three, it's just Big Me. Fighting words, but nonetheless. All right. The question is how one interprets those lyrics and what meaning is given to those lyrics in the context of evaluating the rap battle. Similarly, of course, we don't challenge that there was a rap battle. We plead that in our complaint. Your amended complaint. Because your initial complaint let me look back, so let me not talk out of turn. Because in your initial complaint, you talked about, and let's look at that. Let's be clear. Hold on, let me get to where I'm at. So when I come back, here is the initial complaint. When he started this thing out, he was using Sir Lucius Grange's information, and he talked about in the middle of the night on May the 7th, an armed group of assailants drove up to the Toronto house in which Drake sorry that you all weren't able to follow along. All right. So when he crafted this first, and here it is that you all can see, when he crafted this first response, he was making it. He was making it like, Judge, I'm sitting at home, and in the middle of the night, folks come up in my house. They drove up, and someone began to open fire, and they said F Drake. And all this stuff was going on. We had a car come up to security. The security got popped. We was trying to keep the man alive, the security guard that got popped alive, putting pressure on wounds. Then a different intruder came the next day, used his bare hands to dig a hole under his house. He was like, Your Honor, my home is not safe. And the reason why my house is not safe is because UMG promoted this song, and the song in question was Not Like Us, written and performed by Kendrick Lamar. The recording was intended to convey the specific and unmistakable false allegation that Drake is a criminal PDF file and suggests that the public should resort to vigilante of justice in response. Now, y'all, that is how he crafted. And he says here in number 8, this lawsuit is not about the artist who created Not Like Us. It's about UMG that decided to publish and promote and exploit and monetize this. Because again, in number 7, they talk about the video, they talk about the song, then they talk about the video, then they talk about him promoting it during Juneteenth. And they talked about that UMG did this because they wanted to undermine Drake. They said Drake had never engaged in anything that was going to put him on a neighborhood watch, nor did he have actual relations with a minor. Let's continue because we'll skim through this. They talked about them devaluing his messaging. But as we go through here, they talked about him weaponing the stuff. But they did not say in this initial thing that they talk about that he was part of a rap beef. Let me go, because I don't want to be wrong. They talked about whitelisting. They said UMG had previously published Lamar's song Euphoria, was also widely understood to be targeted at Drake. And he put on there, don't tell a lie about me, I won't tell the truth about you. He talked about all the publicity that he had. Now he's trying to say that this was put in there as we go through here. We're going to continue to go through. Nowhere in the initial filing did he mention that there was a rap beef. It wasn't until UMG decided to dismiss it that he started talking about, well, yeah, we in a rap beef. He posed not one word of the words that he spoke. Now, let's continue. It says, now, the question is how one interprets those lyrics and what meaning is given to those lyrics in the context of evaluating the rap battle. Similarly, of course, we don't challenge that there was a rap battle. We pled that in our complaint. It doesn't say which one. It wasn't the initial one. It had to be the second one when they the second complaint. But initially, they did not do that. What we take issue with is UMG using lyrics to draw inferences about what reasonable listeners and reasonable viewers would have understood about the song in question. That is where the argument strays from what is permissible under the court, judicial notice authority, and also strays. The court. Once the lyrics are in evidence, then of course I can draw inference from them. They are in evidence. They have been judicially noticed. The lyrics exist. They have the meaning that they have, their words. And I don't understand your argument that I could take judicial notice of a song lyric, but I'm not allowed to consider what the lyric means or says. And as I say, for me, context matters. Mr. Gottlieb, because at the pleading stage, the court is not allowed to make inferences against the plaintiff. The court is required to draw all reasonable factual inferences in plaintiff's favor, and the court is not allowed to take materials from outside of the complaint and use it to discredit or undermine or question the allegations that have been plausibly alleged in the complaint. And I think this argument around context is the important example. So far, we have alleged throughout the complaint what the appropriate context for the understanding of the lyrics, the cover art, the video, and the song are. We have alleged that the full context includes the lyrics of the song, the cover art, and the video. And we have explained in numerous allegations throughout why a reasonable listener or reader or observer would have interpreted those songs as conveying a singular and precise factual message that Drake and false message that he is a PDF file. The court, but isn't that a legal argument that I don't have to draw an inference in your favor? Because whether a reasonable listener would have drawn that inference is a question of law, which you've already agreed is a question of law, and legal assertions or arguments made in a pleading do not have to be credited by the court. Mr. Gottlieb, the question, though, is not what a reasonable listener would have interpreted the lyrics to mean. The question is whether a reasonable listener could have interpreted the lyrics to mean, in other words, is reasonably susceptible to a defamatory connotation. That's the Davis standard, and we think we have more than adequately alleged that. But more to the point, we have specific factual allegations in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. What? We have, say that again? But more to the point, because we have specific factual allegations in the complaint that UMG engaged in a coordinated, covert, and unlawful scheme to remove Not Like Us from the rap subgenre and turn it into a de facto national anthem. That's alleged at paragraphs 10, 11, and 128 through 202 of our complaint. The complaint alleges facts showing that UMG wanted to and succeeded in making the song culturally ubiquitous. And this means that the audience, to answer one of the court's questions to my friend, the audience by which to evaluate defamatory meaning in this case is not the people who would be dialed in to every back and forth between Kendrick Lamar and Drake in the rap battle, but the audience is everyone exposed to the lyrics and imagery, not just those sorts of there in the moment. We cite the Lindell versus Mail Media case and the second court that stands for that proposition. This is particularly important because we also allege with specific numbers that this song achieved a cultural ubiquity unlike any other rap song in history, not just unlike the other songs in the rap battle, but unlike any other song in history. More than 9 billion streams at the time of the filing of our last brief have been 9 billion times have been streamed on this song. Every other track in this rap battle pales in comparison to that. So the relevant audience member, if the court is trying to understand the objective listener, objective viewer, cannot be the person who listened to every track in the rap battle. The relevant person is probably your average 13-year-old who's alleged to be dancing to the song at a bar mitzvah, who may not have heard any of these other songs before, or may not even had that much of been a rap fan. The court. That would be a very interesting bar mitzvah that played that song. And Mr. Gottlieb said that's apparently that is very popular at bar mitzvah. The court, I will take your word for it. Mr. Gottlieb. There's a separate set. So you're looking at, there's only, well, we won't go into that. Because I'm just thinking about the swell of that song. And I think the swell of that song came because of the fact that he dropped that song because people couldn't even get into what's the name of the song? We couldn't get into Family Matters because Meet the Grahams dropped. And then we really couldn't get into Meet the Grahams all that way because Not Like Us dropped. And if I'm not mistaken, did Not Like Us drop on a Sunday morning? Was it a Sunday morning or was it a Saturday morning when that song dropped? And so at that point, once it dropped that Saturday, I think it was Saturday morning. Yeah, I think it was Saturday morning because Meet the Grahams and all that. We woke up Saturday morning or Saturday in the middle of the morning and it dropped. So there were people who had time to hear it. And plus the fact that there were a lot of YouTubers that were reviewing it. And then people were listening to it on their own. Then you had celebrities like Rick Rocks and all the people who had been who had been dissed in Family Matters kind of promoting it to their people. Because I do think the song had kind of died down. And then we got, that hadn't really died down. Let me stop. Because that was in May. And then we got to Juneteenth because he did the pop out. And he did play that song during the pop out. And then July 4th, we got the video. I'd have to go back and check Billboard and look at its placements as we were there. But anyway, let's continue. There's a separate set of factual allegations in the complaint that add to this that UMG also doesn't add, and that it contained at paragraphs 90 through 92 of the complaint. We allege in sort of the modern social media environment, allegations of PDF are of the far more relevant social context, and whatever might have been true when Judge Daniels with considering these issues in terrain today, given the massive global audience for this song, that it reached the entire world and the social media environment in which the allegations of PDF land. Today, audiences are simultaneously primed to believe and primed to react with outrage to allegations of harming children. And that is in direct response to many of the generalizations contained in the cases that UMG cites and many of the arguments that they're making. These are specific allegations, paragraphs 90 through 92 of our complaint. UMG is asking you, based on their sort of spin of exhibits, to disregard these well-pleaded factual allegations. Let me go back down. I'm just going to did they say 90 to 92? All right, so let me just read this what they said, because again, they mentioned there are specific allegations at paragraphs 90 to 92 of our complaint. So we're going to paragraph 90 to 92 of their complaint. And it says, in that complaint, it says, less than a month after UMG published the recording and image, author Martin Vidal published an article titled The Drake and Kendrick Rap Beef, a case study of mob psychology. Mr. Vidal explains the mob mentality is a psychological state that causes people to abandon nuance, label anyone who defends the accused as being guilty of the same actions of the accused, reward those who perpetuate their cause, and do bad in the name of doing good, even when the accusations are made without supplying any evidence. Mr. Vidal concludes that the public reaction to the allegations against Drake were classic mob mentality, citing the pew pew and other trespassing instances of vandalisms at Drake OVO stores, and overwhelmingly negative public outcry. Mr. Vidal explains that this mob mentality is why people can believe the allegations, despite the fact that Jake has never been accused of inappropriate behavior with a minor or something similar like grooming by any underage or formerly underage person he's interacted with, or their families or their acquaintances, and just about every alleged victim of such has come out in defense of Drake. According to Miss Mike Rothschild, an author and expert on conspiracy theories, accusations of PDF filing are particularly ripe for conspiracy. He describes the allegations of child sexual abuse can cause people to immediately just lose their minds, even if these children don't exist. And even if you just put out suggestions there, it grabs a hold in a way that's difficult to dislodge. Mr. Rothschild also notes that social media exacerbates conspiracy theories because the spread of information or disinformation can happen so much more rapidly than in the analog age. All right. So let's continue. It says UMG is asking you, based on their sort of own spin of exhibit, to disregard these well-pleaded factual allegations in the complaint about how sort of the world today receive these types of allegations. And we just don't think that can possibly be appropriate at the motion to dismiss phase. The court. Let me go back because we're addressing the various inferences that can be drawn from the lyrics. And one question I have for you is, do I have to draw an inference from the lyrics? Don't they speak plainly? So far, example, let's go back to the Taylor freestyle lyric, which is talk about him liking young girls. That's a gift from me. And in the context with the AI voice of Tupac, it's clearly, one can clearly read it and be a goad from Drake to Kendrick as part of their back and forth in the rap battle to bring up rumors regarding PDF filing and Drake. I don't know how else one could logically read that. If you have an alternate reading, I'd like to hear it. But I don't think I have to draw an extreme inference to understand what that line is. And Mr. Gottlieb said, well, Your Honor, the court, what would be the inference that would be favorable to the plaintiff of that line other than the one that I've just put forward? Mr. Gottlieb, Because, Your Honor, you would have had to consider, as Mr. Ransom says, black letter law and opinion doctrine. You don't slice out a single line or a single statement from a song in order to ascertain its meaning. That makes no sense to me, because you have to go through the song and pull out the lyrics of the song for you to understand what's going on in the song. That's the whole part of music. To get you to think, or to get you to feel, because the song is setting a story, or is setting a story or a plot about what's going on, and you're supposed to interpret what's going on as you listen to the lyrics. I mean, that's the same thing even if you take a love song by Taylor Swift. You consider the entire song and the entire lyrics in context, the chord. But I'm asking you about this line in this song. How would I read it? You said I can't draw inference from these song lyrics. I can just consider their existence. But do I have to draw an inference? And Mr. Gottlieb's, yes, you, the court. The words are the words. Talk about him liking young girls. How else would I read that? Baby. Just just as she got spicy with Mr. Ransom, she is getting spicy with Mr. Gottlieb, because she is wanting to know how she's supposed to read that. How is she supposed to read that? Because you can't have it both ways. You either interpret the lyrics as you see them, not that you could just say, oh, here's this song. Well, how am I to know that this song is defamatory if I don't read the lyrics and take the lyrics at heart? If I don't have the context of that, how am I supposed to know that this is defamatory if I don't even have the context of what's going on? Because the initial complaint, you didn't mention a rap battle. You didn't mention the rap battle until UMG filed their motion to dismiss, the initial motion to dismiss. And you are talking, they are referring to now their amended complaint. I don't know if they thought in that initial complaint they were going to pull on the heartstrings of the court. The court is not supposed to do that. But they fashioned that initial complaint as if somewhere out of the blue, this song dropped from the heavens and Kendrick Lamar sung it, and then all of these chains of events happened. Because even with this, they are conflating that the lyrics are causing the violence that was set upon his house. And they're not even talking about the fact that even during this Kendrick Lamar and Drake beef battle, Drake and his camp was engaged in a battle between The Weeknd and his label. Even to the point where The Weeknd's manager's home had someone break in and pew their security guard or shoot at the security guard. There's more inference to believe that, in my opinion, because again, this is just my opinion and that's all that it is. It's my opinion that there is more inference to show that it might be possibly linked to that than to what's going on now. I will concede that what happened over in London may have been directly impacted by this song, but let's continue. But that's not how he did it. Now they did, like I said, they did an amended complaint, and we'll go over that as such, and we are going over that as such.
But I just wanted you all to know that that's not how they started this. They had this particular song in isolation. And the only reason that they made a reference to the rap battle was because UMG asked to have this case dismissed the initial time. And in the process of them asking to dismiss that initial, they amended the complaint. So that complaint is no longer looked upon. We have this amended complaint, is which they're referring to. Mr. Gottlieb, Your Honor, I don't understand what legal relevance that has to the question of how a reasonable audience member would have understood the lyrics in Not Like Us. Before you even get to talking about the lyrics in his prior song, you would have to come to the conclusion that your average listener to Not Like Us came into the song with that lyric in mind, had heard that song and had been exposed to it, had understood the lyrics in the same way that Your Honor is reading them. And there's simply no basis in which to make that determination at the pleading stage of this case. They may come forward with evidence. And she says, let me have you pause here. But here's the thing. His argument earlier before about social media. The world is connected via social media. So the world heard about this rap battle before the song Not Like Us dropped. Particularly those that are in, because again, with Drake, who his audience is, and I've talked about it probably ad nauseum now. So those people would have been particularly in tune with this rap battle because of Drake. These are his audience. These are the people. Would there have been other people that would have been interested in the rap battle? True. But if you're not listening to the genre of music, you wouldn't have known anything about it. So let's continue. The court. Let me have you pause there. I understand that a lot of these cases arise in a very traditional context of a newspaper article or an op-ed or a single communication. But here we have songs that are in communication with each other, a dialogue with one another. One artist releases a song. A few hours later, another song is released that responds to that song, and back and forth. That is the context in which these lyrics arise. So to take Not Like Us as the specific example, just to isolate it, isn't that taking it out of the broader context in which it existed? And that's the crux of the whole thing. And I love how she put that these songs are a dialogue with one another, a communication with each other, that they are talking to each other. And there just happens to be an audience. Now, y'all stay with me a little bit because I don't know how this works out. This is just like if you're walking, let's say in the mall, and you come across two people that are arguing with each other, and all the expletives and all this other stuff is flying around. Somebody is a B this. Somebody has 4 kids with the guy that everybody asleep. Whatever it is, you come up across all of this stuff, and all of this stuff is said in the context of this dialogue. Listen to how she put it. A dialogue with one another. You two are going back and forth with each other. You're giving as good as you take. And we are the people that have come across this dialogue. So if you two are in this context of this dialogue, and both of you all are saying things and spewing things at each other in this dialogue, even though this dialogue is both of you are tearing each other down with words and rumors and innuendos and all of this stuff coming out, and you're going back and forth with each other. As long as that communication was going back and forth, that's the context of this.
So in my mind, and y'all let me know if I'm on this, in my mind, if you got two people battling each other and they're spewing stuff out, that's the context of this thing. How are they defaming each other when both of them are out here spewing stuff to each other? It's not like this one person, like she's talking about. It's not like Kendrick or Drake sat down to write in a newspaper this information about each other. They never are talking with each other. This right here is a dialogue with one another, which is an interesting place to put that. That's very interesting. That is very interesting. That is the context in which these lyrics arrive. So to take Not Like Us as the specific example and just to isolate it, isn't that taking it out of the broader context in which it existed? It would almost be like taking a single paragraph out of an op-ed and not looking at the headlines in the remainder of the article, because you can't look at Not Like Us in isolation. It is a response to what has come before. And that's what everybody else is getting. Everybody else is getting that. It is a response. It wasn't that Kendrick got up one morning and said, I'm fixing to put out this. It's a response to what Drake had put out before. Because again, in Euphoria, he said you got chipped by a throwaway. That was a throwaway verse that I put on Future and Metro Boomin's Like That. That was a throwaway verse. And you came out with push-ups and tailor-made freestyle. We're going to continue, but I just got to get this out. You goaded this man to come out. It was like you were standing at his front door, goading him out because you heard him say, bump the big three, it's just big me. But he was responding, even that throwaway. He was responding to what you all said in your song with J. Cole. First person shooter. So in essence, Kendrick is just responding to you. So how you gonna get mad? Mad and sue when he is in response to you? You can't dictate someone's response to your disrespect. You can't dictate that. And then you try to make it seem like his response to your disrespect is the initial action. And I talk about this all the time. When you talk about any of these wars, whether you're talking about gender wars, whether you're talking about diaspora wars, when you're talking about all of this stuff, everything is a call and response. And that each faction is trying to make it whatever their response. Oh, well, that's the initial cause of the action. No, it's not. Not Like Us was a response to not only push-ups and tailor-made freestyle, but also Family Matters. And it also piggybacked off its initial responses of Euphoria and 616. Because even when you look at 616 in Euphoria, he said, this is a friendly fade. Let's keep it that way. 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 Because he knew about some stuff that Gunna Wanna would make Gunna Wanna look like a saint. So whatever it was, he's like, hey, you need to stop. I can't stand you. See, here are the things that I don't like about you. I don't like the way that you walk. I don't like the way that you talk. And I don't like the way that you dress. I don't like the way that you sneak this. Because he told you right then, if he catch flight, it is going to be direct. He is going to directly talk to you about this. And then he told you in 616, hey, I know you coming out with that heat, but I'm letting you know the reason why I know you're coming out with that heat is because somebody in your camp is snitching, is letting me know that you're about to come with that heat. And what I'm telling you is, don't do it. Because the gloves will be off. Don't do it. Let's continue. Mr. Gottlieb says, so, Your Honor, we're not advocating for the court not to consider the context. And again, I go back to that initial filing, but I'm going to let it go. Because that's exactly what they were doing. This song was the penultimate track in the fact. Penultimate. Y'all can't be using. I enjoy you using these big words. I hate when it does this. I just asked you to look up something. Hold on, y'all. It says penultimate track in a rap battle. So the word is defined that last one in a series of things, but it's second to the last. So it means second to the last because the Heart Part 6 was the last track in the rap battle. That's not our argument. Our argument is that this song in particular, both in the rap battle and the history of music, all right, I'm sorry, y'all. Okay. Anyway, I'm sorry. That word has struck me. Our argument is this song in particular, both in this rap battle and in the history of music, is different. It is different in ubiquity it achieved. So its audience was different. It was different in the fact that it was immediately understood in the allegations of our complaint to contain a precise factual allegations and a single factual allegation, the false allegation that Drake is a PDF file. We allege, and then the court stops him right there and says, at the time Kendrick Lamar released this song, there was no ubiquity. There was obviously, he's not a fortune teller. He wasn't going to understand that at the moment that he released that song, it was going to have 8 to 9 billion streams and he would be singing it at the Super Bowl. Judge? What? He was releasing it as a part of this back and forth that occurred over the matter of days. And isn't that the context in which I need to understand the assertions made? Not 6 months later, that millions and billions of people have now listened to it and may not have had the understanding, but at the time the statement was made, it was in direct response. And let me give you a hypothetical, she says. If two people are arguing in this, didn't I just say that? And let me give you a hypothetical. If two people are arguing in the streets and throwing insults back and forth, and then later one of them says, okay, that particular statement was slander. You've defamed me. I've had to know what the interchange between those two individuals were that were throwing insults to understand the full context in which whatever statement was made. Isn't that comparable here? Someone insults, the other person responds with further insults. The other person responds with other insults. How can I just take one of these songs in isolation and apply a completely different standard to it because 3 months later, billions of people have now listened to it? That is the question. That is the question of the year. Doggone it, Diddy. There was so much juice in this one. Shout out to CJ. She said that this was juicy. And shout out to all those people, whoever worked on the project of making these insulated cups, from Yeti to what is this one? I don't remember. I got this one from Walmart. I don't know if you can see that. I got this one from Walmart. And then the Stanleys and all that. Shout out to those insulated these insulated things, because baby, it's nothing like when you started off, it starts you off. If you had something ice cold, it continues to be ice cold. If you have something hot, it continues to be hot. I think it stays colder than it does hot, but still. That's the question. And I think that let me copy and paste this. I'm going to do her whole thing because I want that to be in context. Hold on, y'all, because I'm doing this because I am going to do a separate video in regards to this. Let me just can I highlight this? Keep it highlighted. All right, we'll come back to that. What is that? Let me do this. All right, let me continue. It's almost scary that you think like some people, but let's get to what Mr. Gottlieb said. Your Honor, I appreciate the question. I think it stems from a lack of grappling with, and perhaps due to imprecise briefing on our part, the nature, the role that republication plays in this case. We have alleged in our complaint, I believe, in 11 separate paragraphs, and in the amended complaint, that UMG was responsible for republication of the defamatory material. He hadn't answered her question. He's just talking about that's paragraphs 1321, 121, 120, 120, 121, 157, 191, 192, 232, 241, 246, and 266. The standard for republication is that a defamatory statement is republished whenever it is intended to and actually reaches a new audience. That's the New York Court's Appeals decision in Firth versus State. We allege throughout our complaint that UMG said nothing about it until their reply brief in this case. So we have alleged that UMG took steps at multiple times post-May to republish the material and introduce it to new audiences. And each time it did that, it was liable for that republication. And each time it did that, its knowledge at the point in time becomes relevant. And we have pleaded that knowledge in the complaint, including what it knew in July and what it knew in August based on retraction demand letters that we sent to it. What it knew when it launched the Grammys campaign, what it knew when it launched the Super Bowl campaign. Again. Had Drake done the same thing and launched that and was about to get a Grammy for Family Matters, this wouldn't be an issue. And again, this was information going back and forth. Drake gave him the in to talk about him liking little girls. Again, you can't give nobody nothing and then get mad at the delivery of how he delivers it. And you wanted them to stop. And again, this is the part that I've talked to you all about that I think UMG has an issue, is because when Drake wanted them to take this stuff down, they were taking stuff down. And they have made inferences to the beef with Pusha T. And they have made inferences to songs and things like that were to be published that Drake did not want to be published out here on these airwaves. And they have acquiesced to Drake in regards to that. The one time they decide not to acquiesce to Drake, we have this lawsuit. So partly they bring this on themselves. But again, in the context of this whole thing, it is like she said, and I said it earlier, I didn't realize, because I haven't read this before. I didn't realize that she was going to use that example as I use that example. But it's like you see 2 and 3 people fighting. And if we put it in this social media context, if somebody was standing around those 2 people as they were arguing back and forth, and somebody recorded it, and then they split up and somebody recorded person A still saying some stuff about person B, and somebody else recorded person B still saying some stuff about person A, and they put it all on social media. What are we now talking about? Because, well, that's a bad example. That if they put that information out of both of them fighting each other, both of them saying terrible things about each other while they're standing there having a fight, and somebody records it, and then someone puts that on social media, and then they take everything that one person says and they clip it and they send it out, in context, we got to look at it in context of what the whole thing was. Both of them were going back and forth. And that's what's happening. They're going back and forth. You told him to do it. He does it. Now you're mad that he did it so eloquently. And you're mad that the people that listen to it did Grammy. They put it forth for a Grammy. Who wouldn't? If Family Matters had garnered all of that, if push-ups, well, they couldn't do that, but if push-ups would have garnered all that, y'all, the way we would have seen Drake at the Grammys. And we pleaded that knowledge in the complaint, including what it knew in July, what they're talking about, what UMG knew in July, what it knew in August, and when it launched the Super Bowl campaign. But even if you don't agree with us on that, we allege in the claim before you get to republication that the defamatory material includes the song, the cover art, both of which were released on May 4th, and the video was not released until July, 2 months after the release of the song. And UMG acknowledged at the time that it released the video included all the information that we have alleged in the complaint, including the attacks on Drake's home in Toronto, 3 separate attacks in his home in Toronto, the attack on his OVO business in London, the fact that users all over the United States were commenting on him being a PDF file, and that Drake had denied factually in the allegations in the Heart Part 6. We make all of those allegations in the complaint about UMG's knowledge at the time of the publication of the video. So that's the latest point. That's the earliest or latest, but their knowledge clearly at the July point in time before you even start talking about liability for republication comes into play. Then, Your Honor, with respect to your question before about sort of removing the song from the factual context of the battle, and doesn't it sort of have to be understood that way? We all have alleged that this song was actually understood as a sort of singular entity because of its cultural ubiquity. No. Who knew at the time it was going to get this big? Nobody knew. No one had a projection rate that it was going to be this big. Nobody. Keith Sweat could have told you that. Nobody. So, we make all of those allegations. Well, excuse me, let me go back up further. And here, I'm going right here. The fact that Drake had denied factually the allegations in the Heart Part 6. So let's do this. Oh, okay. This is what the YSL prosecutors were doing, taking singular lines and trying to change the context. Ooh, and then what shatters my soul is that you sat up here about that, and this is what's so crazy about this whole situation is that you sat up here and signed a whole petition about that, about them doing that to YSL. And here you are turning around and trying to do the same thing. Sure. If you did need an example about how they're not like us. So let's do this. Here we have the lyrics to the Heart Part 6, because again, he's saying that, in fact, that Drake had denied factually the allegations in the Heart Part 6. So let's see what he said in the Heart Part 6. It says, the Pulitzer Prize winner is definitely spiraling. I got your effing lines tapped. I swear that I'm dialed in. First, I was a rat, so where's the proof of the trial then? Where's the paperwork or the cabinet is filed in? 1090 Jake would took all of the walls down. The streets would have had me hiding out in a small town. My Montreal connects stand up, not fall down. The ones that you're getting your stories from, they're all crowns. Now, he is responding. Now, this again, going back and forth, they're going back and forth with each other. He is responding. This is a line that's in response to Kendrick's 616 in LA song. Because he said, did you ever think that OVO was working for me? And he's saying that the ones that you're getting your stories from, they're all clowns. I am a war general, seasoned in preparation. My jacket is covered in medals, honors, and decorations. So basically what he's saying is, I'm in this rap game. I've got plaques. I've got all kinds of stuff to show that I am this rapper. You waited for this moment, overcome with desperation. We plotted for a week, and then we fed you the information. Now, let's go back up here. The ones that you're getting your story from, they are all clowns. So that means that you know who these folk are. But they're all clowns. Then he turns around, he says, you waited for this moment, overcome with desperation. We plotted for a week and then fed you the information. A daughter that's 11 years old, I bet he takes it. We thought about giving a fake name or a destination. But you so thirsty, you're not concerned with investigation. Instead, you in that Venice studio, it's a celebration. You got to learn to fact check things and be less impatient. Your fans are rejoicing, thinking this is my expiration. Even the picture you use, the jokes and the medication. Now he is talking about that picture of the cover art for 616. And I also think Meet the Grams. I think that's the cover art for both of them. And he's talking about all that information that's on here. Now he's talking about that. And then he calls him master manipulator. You beat on the speculation. So you're saying that you gave him that information. You gave him the information about the daughter. You gave him the information about this suitcase or whatever. It's Meet the Grams. Thank you. You gave him that information. He says, you dumb, reactive N-word. I'm petty with dedication. What about the bones we dug up in that excavation? And why isn't Whitney denying all of the allegations? Why is she following Dave Free and not Mr. Morale? You haven't seen the kids in 6 months. The distance is wild. Dave leaving heart emojis underneath the pics of the child. Speaking of anything with the child, let's get into that now. This Epstein angle was the S that I expected. TikTok videos you collected and dissected. Instead of being on some disdirect shit, you rather effing grab your pen and misdirect S. All right? This is what he says. And he says it here. The Epstein angle was the S I expected. TikTok videos you collected. So you already knew that there was a whole aspect of information out here in the whole zeitgeist of the social media space. You knew it was out here. She said, my mom came over today and I was like, mother, I, mother, I, mother, ah. Wait a second. That's the one record where you say you got touched. Ah, F me. I just made the whole connection. This is about to get so depressing. This is the trauma from your own confessions. This is where your father leaves you home alone with no protection. So neglected. That's why these PDF file raps and S is you are obsessed with. It's so excessive. They acting like it's so aggressive, but you never known affection. I don't want to dish you anymore. This has really got me second guessing. Touch My Body by Mariah Carey play, you probably start reflecting. I never been with no one underage, but now I understand why this is the angle that really messed with you. Just for clarity, I feel disgusted and I'm too respected. If I was effing young girls, I promise I'd have been arrested. I'm way too famous for this S you suggested. No one is too famous for it. No one. No one. Because even if we talk about that, sometimes some of this stuff don't come out for years later. Because I'm willing to bet you, not for sure, but if we ask these people that you were texting to provide those texts, and again, I'm not saying that he is, and I'm not saying that he isn't. All I'm saying is if you are like me and you've been listening to rap music, this is stuff that's been out there. Now, D cups that never got healed and now they got infected. Like if Dave really effed your girl and got her pregnant, talk about breeding resentment. I'm not sure how to ease the sentiment, but this S is too intimate. I'm praying you recover from both incidents. Now, again, he's doubling down on that Dave free. He says, but you're a piece of S, and so this S is really no coincidence. Drake is not a name that you're going to see nor on no ex-offender list. Easy does it. You mentioned A minor, but N-words got to be sharp and tell their fans who was it. You thought you left D flat, D major. I'll slit your throat with a razor and do Rick Ross air like Flight from Malaysia. Because if you don't know that Rick Ross air Flight from Malaysia skidded off the runway. He says, I'm a hit maker, dog, not a peacemaker. Yeah, bullets that I'm stuffing in each chamber. Your butt is in extreme danger. So stop buying views and bots comments. You may as well keep the paper. You about to need for later. I give a F about your streaming data. So he said he didn't even care about the streaming data. You could drop 100 or more records. I'll see you later. Yeah, maybe when you meet your maker. I don't want to fight with a woman beater. It feeds your nature. You still bumping R. Kelly. You could thank the savior. Said if they deleted his music, then your music is going to. A hypocrite. I don't understand why these people praise you. Sounded like you send him commissary when he needs some paper. Album dropping soon. No wonder you turn to a clout chaser instead of doing hard labor. N-word, I'll see you when I see you like Fantasia. And Whitney, you can hit me if you need a favor. And when I say I'll hit you back, it's a lot safer. I promise. I'm not going to lie. This S was some good exercise. Like it's good to get out and get the pen working. You would be a worthy competitor if I was a real predator. And you weren't effing lying to every blogger and editor. But it is what it is. So did Kendrick do interviews that I wasn't aware of? He says, was there interviews and stuff that he did? You definitely got this stuff burnt the F up out though. Like you got 10 more records to drop. The one before the last one, we finessed you into telling a story that doesn't even exist. And then you go and drop the West Coast one to try to cover that up. You don't even make any sense. You got, well, I'm not here to dissect. You know, at least your fans are getting some raps out of you. I'm happy I could motivate you, bring you back to the game. but just let me know when we're getting to the facts. Everything in my stuff is fact. Prove it. I'm waiting on you to return the favor. Who's supposed to prove it? Everything that you said that you spit is facts. Actually, is the guy. I don't know. I don't remember reading anything about him per se, but that doesn't mean he's not there. And I will tell you my memory of reading that. I read these lawsuits back in January, February, March, and then I jumped into the Diddy case, so I can't remember off the hand if he's in there. Mm. Okay. Okay. So let's get back into the oral arguments because we just read what those lyrics were and what he said. So I'm going to read to you because I'm going to read it in its entirety because this is what's interesting. So, one thing about Genius, they go and they research, they have some people that contribute to and research what's been going on and what's been said. So, what I want to really quickly do is to read. Let me show you what I'm looking at. So, I highlighted. Let me see if I can make this fit. What is going on? Why is this not coming down? Here we go. I highlight this part, but just let me know when we're getting to the facts. Everything in my stuff is a facts. And he got in quotations, prove it. I'm waiting on you to return the favor, like. And so here we go. It says that Drake claims that Kendrick Lamar's diss track in the feud have been full of lies, while Drake's has been nothing but facts. One of Kendrick's most notable allegations was Drake was hiding an abandoned 11-year-old daughter on the diss track on Meet the Grams. Kendrick rapped, "Dear baby girl, I'm sorry your father's not active inside your world. Should be teaching you timetables or watching Frozen with you, or even at your 11th birthday singing poems with you." However, earlier in this track, Drake claimed that he intentionally leaked this false information to Kendrick to make a fool out of him and essentially to waste his time creating a diss track that is predicated on false information. He said in The Heart Part 6, "We plotted for a week and then we fed you the information. A daughter that's 11 years old, I bet he takes it." And another prominent theme in Kendrick's diss track was claiming that Drake is a PDF file. For example, on Not Like Us, Kendrick explicitly said, "Certified lover boy, certified PDF file." However, earlier in this track, Drake denies these allegations and claims they are simply projection of Kendrick's description of ex abuse essay as heard on Mother I Sober. Some of Drake's most notable disses against Kendrick are that he physically abused his fiancee Whitney and that one of his children's biological father is actually Dave Free, Kendrick's childhood friend and manager. Drake claims these allegations are true. However, no concrete evidence has been provided for any of these allegations by either side. And without receipts from either side, this is simply a game of he said, she said. And we got a thumbs up, 92 thumbs up for this. And then there's some comments in regards to this. We got a contributor saying, No concrete evidence from both sides. So why is Drake acting like all he air out bringing these receipts? There are no facts from Jake yet. Where's the receipts? Or it just says receipt. Sorry. We've got, look at the stats. I've got the facts. My money, like Lizzo, my pockets are fat. I don't know what that means. 6 months ago. It says, so basically the proof of Kendrick Lamar is that Drake is the mole. I like that Kendrick and his track didn't say who the mole was. So if they go to court, he can finally say that Drake, you're the mole because you literally said in your lyrics that you leaked to me the information that someone was in your team was you. It doesn't have to be any harder than what these Caucasians are making it to be with these weird explanation. Anybody with a brain or even a child can understand that there is a contradiction. The good old meme, hey, wait a minute, he's just contradicted himself. And then they say here, because Dave Free and Whitney came forward and denied them if they were false, just like Drake's SA victims can come forward and confirm it. Also, where is Drake's daughter, Crody? Now, this isn't a rap battle anymore. And I wanted to just go that because, again, Drake's lawyer is saying that they told UMG that all of this stuff was false and that they should have taken it down. So it looks like if that was the impetus, it looks like UMG should have taken all the songs down. All right, let's continue with the thing because we want to get off here. We got about 20, maybe about 20 more pages, and then we're done. It says here, we make all of those allegations in the complaint about UMG's knowledge at the time of the publication of the video. So that's the latest point. That's the earliest or latest, but their knowledge clearly at the July point in time, before you even start talking about liability for republication, comes into play. And then, Your Honor, with respect to your question before about sort of removing the song from the factual context of the battle, it doesn't sort of have to be understood that way. We have alleged that this song was actually understood as a sort of a singular entity because of its cultural ubiquity. And even the exhibits that UMG has put into its request for judicial notice, they prove this. So, for example, UMG has Exhibit P, which is a podcast transcript. We cite a piece of it in the amended complaint. At page 4 of that podcast transcript, there's this discussion about how Kendrick is making allegations about Drake. And it says, quote, some of these things have been fact checked. And then later on down, one of the commenters says, I don't know if there's ever been a time when a rap superstar or two rap superstars are contemporaries and one is accusing the other of PDF filing, like in the loudest possible way. It continues, contemporaries, people who are making their record label billions of dollars, right? That doesn't usually happen at this level of allegation. Maybe it should inspire some sort of investigation. Later on page 5, it says, one of the commentators says, it's unclear right now the claims of Kendrick Lamar's DV are true, but let's talk more about these allegations around Drake. No one has previously called out Drake this way. Now it's being raised to a more mainstream conversation because it's a hit that Kendrick is making. Your Honor, Exhibit B to UMG's request for judicial notice, page 10, the commentators describe Kendrick Lamar in this song as, quote, indicating Drake for years of rumors and speculation. Indicting, meaning a specific factual charge being made in a song based on rumors and speculation. Notably, Not Like Us doesn't include the rumors and speculation in it. It doesn't talk about any of the underlying rumors that Mr. Ransom was talking about that Drake allegedly had to deal with in his past. It only includes the indictment, the specific charge that he is a certified PDF file, the cover art, which is his actual Toronto home, which, by the way, is also validated by another exhibit that UMG wants you to take in notice of, Exhibit J. Page 4 describes the content of the song as ex-offense allegation, essay allegations throughout Not Like Us. Kendrick accuses Drake of having inappropriate relations with minors. However, Kendrick does not shy away from blowing up the rumors surrounding Drake's personal life with his lyrics. Later down, the predator accusations include the cover art for the track. In fact, an aerial picture of Drake's mansion allegedly dotted with ex-offenders' location tags. These are their exhibits from commentators interpreting the lyrics of the song contemporaneously, understanding it with a precise meaning that can be fact checked, that can be proven true or false. So if these things are in the record, we're fine with it because they all prove that there is a susceptible connotation that can be drawn that the song had a precise meaning. Your Honor, I don't know if the court, and then she said the court chimes in. Let me ask you this though. Your client also, in the course of this rap battle, leveled accusation against Mr. Lamar as well, that he's not the biological father of his child and he beats his girlfriend. Are those facts or opinion? Mr. Gottlieb, are those, I'm sorry, Your Honor, the court, are they fact or opinion, those lyrics? Mr. Gottlieb, I don't know that the court has a record sufficient to be able to make that determination because the court doesn't have the context behind all the different allegations in the song. There isn't a complaint with 250 allegations giving meaning to the lyrics. We don't know. Was there cover art? We don't know. Was there a video? We don't know. Was there a singular message? We don't know how people understood it. So that is both a determination that the court doesn't need to make here. Oh. So all that what he says, we don't need to worry about that. All we need to worry about is what Kendrick Lamar said. Okay. Nor is there one that the court has a record to make here. That could be the subject of questions that I imagine UMG will want to get into the discovery of this case. But it's certainly not a reason to find that the pleadings failed to state a claim on which relief can be granted. I don't know if the court wants me to address actual malice arguments that have been made, the court. I do not need to hear arguments on actual malice. Okay, the court. If you would like to briefly address the other two causes of the action in the complaint, however, Mr. Gottlieb, sure. So with respect to the 349 claim, Your Honor, Mr. Ransom made essentially two arguments. The first is that he's made an argument about information and belief pleading, and the second is about the injury element. So let me address the information and belief pleading. I think this argument just simply misunderstands the nature of the allegations that we make in the complaint. And so we don't think it actually matters whether the court concludes what the standard on information and belief pleading is. Even under the standard that UMG articulates, we believe our allegations meet for that purpose of Section 349. So we essentially made four arguments that support the underpinning factual allegations of materiality and consumer harm under Section 349. The first argument we've made is that UMG misled streaming consumers by paying or by causing payments to be made to third parties to have bots artificially stream the recording on Spotify to boost streaming numbers, and that paragraphs 173 and 178 of the amended complaint. Now, UMG said this is based on information and belief, but the standard here is plausible under Iqbal and Twombly. And we more than meet that standard for the following reasons. So under paragraph 174, we allege that fake streams are a huge problem in the music industry and that UMG hasn't disputed that up to 10% of all music streams are false. And in 2021, 1 to 3 billion fake streams across popular music platforms were fraudulent. If that's the only allegation we have, we agreed we'd be in a bad place on information and belief pleading. But we continue that in paragraph 175, fake and manipulated streams are significant problems for Spotify, which invests heavily in their reviews on it. It is reasonably it is a reasonable inference that Spotify would not make heavy investments on a non-existing problem. We also allege that Not Like Us set records on numerous streaming platforms. It was the fastest song ever to reach 300 million Spotify streams in just 35 days, which is paragraph 130. And one popular inference of this, which we believe the court must draw at this stage, is that this unprecedented rocketing up the streaming chart, that UMG was using a technique that it eventually used on 10% of all music streams to manipulate stream totals. Now, UMG does not dispute any of the paragraphs from paragraphs 129 to 171 addressing its completely unusual and unprecedented tactics in promoting the popularity of Not Like Us. That includes things like whitelisting agreements with other parties. All of those allegations I just referenced are the background for the pleading for the allegation that UMG describes as information and belief. That background supplies the context for paragraphs 176 and 178, which are based on three things. One, a popular podcast host who insists that he knew that Not Like Us used bots. Second, are users in social media claiming to be music industry whistleblowers who witnessed the buying of promotion through a digital marketer. And third, a self-proclaimed retired stream farmer who posted a video in which he claimed to show how a streaming bot had UMG and Kendrick Lamar used to boost Not Like I Stream in their beef with Drake. These are individuals who purport to have firsthand knowledge. They're included in our complaint, and they are all consistent with the underlying and background allegations that preceded. This is an entirely appropriate allegation on information and belief. And under the authority that we have cited, these are particularly appropriate information and belief allegations when you're dealing with a covert scheme where, in order to complete our proof of the claim, we rely upon evidence that is in the possession of the defendant. That is the authority that we have cited, which also cites cases from Second Circuit at this point. We make three other arguments on this, and I'll only mention them very briefly. The second is that UMG provided financial incentives to streaming platforms to promote the recording and recommendation playlists and search results. And in particular, this is important because it relates to the injury argument, which I'm about to get to. We allege that UMG charged lower than usual licensing rates in order for Spotify to recommend Not Like Us. And we allege in paragraphs 180 and 183 numerous examples of users who describe searching for other music, including searching for Drake's music, and being directed to Not Like Us. Now, there was a video in regards to that. And then they said that they used some words, but then they looked at the search keywords and stuff like that. So all of that came up. Now, the thing that they're not addressing is the complaints that Spotify got back. What was it? 2017, 2018? Y'all remember that? That Drake's what was that album that he was promoting at that time, y'all? Hold on. Hold on. Was it Scorpion? That was 2018. And when Scorpion was on every playlist, even the polka music playlist, that they recommended Scorpion, even in genres that wasn't even rap. And the people complained that Drake was being mentioned to so many different places in different genres that the people were complaining, because the people who love polka music or hard rock music or Christmas music, Drake's playlist was being recommended. Do y'all remember that kerfluffle? And again, I'm not saying that it did or it didn't happen, but we do know that UMG has done some things. We do know that UMG has done some things, and this is why Drake can come back and kind of throw it in their faces, because he has been the recipient of these things. So let's continue. This is all legalese instead of understanding of the context of the rap music and its history. That is true. And they have to put it in this thing. Because see, the thing that I don't think people get about all of this, because they have to cite these cases because those are the only cases that they cite. Once this is over, this is going to be a case that's going to be cited as far as how this judge particularly rules, and this has big implications for the genre of rap music. And the implications are as follows: if this goes through, if this case is to go through, if this case is to be litigated, and I know a lot of people would love for this case to be litigated because we can get back and to go over this beef. But I am hoping that this case is dismissed because this leads to censorship, in my opinion. Because if this case is won, that means that all of these rap songs will have to go through a censorship, and it has to go through a fact checking. So if you are on a song and you're beefing with somebody and you say that their booty is fat when their booty is flat, and it rhymes with something intact, all of that is going to be censored out. Songs are not going to come out like they need to come out because they're going to have to go through some kind of censoring. So again, I hear what you're saying, and I hear about all this legalese, but we have to get back to the importance of what this is, because the reason why that they have this ability to have this free speech in these songs, you have to go back to that case that 2 Live Crew had to win. And that them talking about these overly sexually lyrics were covered by free speech. So we definitely have to talk about this context. And like I said, there was a statement that was said earlier by the judge that I think that this case is going to go to court, but she's also making great arguments like, you can't say it's defamation and try to isolate this particular song. And hopefully that would be the basis of her denying this case, dismissing this case. You can't say or use this song to stand out and say that this song was detrimental when it was a back and forth. And when he said, like she said, in tailor-made freestyle, he told him to bait him like this. And what do you call people? He wanted to put it in a way that, just tell him that he likes young girls. What is the word that is ubiquitous for an adult male liking underage females? What's the word? The word commonly known. You're a PDF file. That's what's commonly told. Now, if we want to get specific and get to the very usage of that word, PDF file means that you like girls that are pubescent. This is before they start any signs of puberty. There are other 2 different words. What is it? Hebephile and something else. There are other words that describe you actually liking teenage girls. But the word that everybody knows is PDF file. Again, y'all, you can't throw something out there and then get mad how people are responding to it. But you're right, Rico. Rico. Let's see what else you got. It's funny because that was debunked rather quickly on Reddit about the bot stream farm or whatever. Even Ack admitted on his stream that Kindred Self were real numbers from Spotify. True. Now, this argument happened in June. And so I don't know if this argument was taking place or had happened before or after his information came out. I am not completely sure. Well, no, this was June of this year. I'm sorry. I take all of that back. Yes, it was debunked. You're exactly right. It was debunked. So them bringing all this information up doesn't make any sense. So maybe in the rebuttal, we'll hear about it. But thank you so much, because that right there is good. All right. Let me get out of the comments and let's get back to it. We make three other arguments that I'm only going to mention briefly. The second is that UMG provided financial incentives to streaming platforms to promote the recording and recommendation playlists and search results. And in particular, this is important because it relates to the injury argument, which I'm about to get to. We allege that UMG charged lower than usual licensing rates in order for Spotify to recommend Not Like Us. And we alleged in paragraphs 180 and 183 numerous examples of user who described searching for other music, including searching for Drake's music, and being directed to Not Like Us, both on the Spotify platform and on the Apple platform. That is quite important to the injury allegation. And as it's been mentioned, this was also mentioned because Drake's music came up, but because if you type in Certified Lover Boy is an album of Drake, but it's also a lyric in the song Not Like Us. If you type in Young Thug, what are those artists? If you type any of those Atlantas, if you talk about those things, are going to come up under Not Like Us because they were mentioned in the song. Baka, if you type in Baka, he's mentioned in the lyrics in Not Like Us. Quavo, you type in Quavo, that's going to get you to Not Like Us, because Quavo, not only is he an artist and not only does he have different albums and songs, but his name, Not Like Us, is going to come up because his name is a lyric in a song. Young Thug, same way. God's Plan is going to come up. That's a song by Drake, but it's also a lyric in Not Like Us. The Family Matters. Not only is it a diss track by Drake, it's also mentioned in Not Like Us as a lyric in Not Like Us. I don't know if it was happenstance or was it by design. Let's continue. Because I'm quite sure if you type that up in Spotify, that's what's going to come up. Even when you mention the name Drake, Drake's playlist is going to come up and Not Like Us is going to come up because Drake is a lyric in the song. You mentioned Chubbs, Baka, Certified Lover Boy. Pac, even Cole, Owl. And I'm just pulling up words that I know that are associated with Drake. OVO. Wayne. D-Roz. Serena. These are all words that are associated with Drake, but they're also associated with Not Like Us because they're in the lyrics. 69 God.
Future, Lil Baby, 21, Quavo, 2 Chainz. Like I said, I don't know if that was happenstance or was it by design. But every time I'm quite sure if you typed one of those words into Spotify, that Drake is going to come up and not like. Like I said, I don't know if that's happenstance or it's by design, but baby, that is something. The last two allegations are the pay for play payola allegations at paragraph 184 to 188 of the complaint, and the misleading statements that UMG made about the recording, streaming, and radio successes, while knowing that such successes were inflated by its deceptive scheme, and that paragraphs 130, 154, and 155 and 257 of the amended complaint. All of that is entirely appropriate under any pleading standard when considered in context. The second argument that Mr. Ransom made was about the injury element. Mr. Ransom argues that the injury is too attenuated. There are too many steps in between Drake suffering harm and the alleged harm to consumers. That's simply not the case. So just as I explained, as we have alleged in paragraph 180 and 183, the scheme that we have alleged misdirects consumers away from Drake's music as a result of manipulation of the search function on Spotify and Apple. And the result is that the consumer was misled into streaming Not Like Us rather than Drake's music. We have also alleged that this caused direct financial harm to Drake, not indirect financial harm to Drake, in paragraph 229 of the complaint, where we explained that reduced streaming rates translates into reduced royalties. So before you get to an argument about, and then the court says, can you just explain to me, and I'll express some ignorance as to how whatever algorithm applies to Apple Music and Spotify work. But how is this either the streaming bots or the pay for play related to the notion that if one went on to Spotify and tried to play Drake's music, you would be redirected to Not Like Us? The connection between those two things is not entirely clear to me, and perhaps it's because of my lack of familiarity of how these platforms work. And so, Mr. Gupp, so the streaming and bot farm is distinct from that claim, Your Honor. So the streaming and the streaming fraud allegations was sort of the first set of allegations I listed out. The payment of financial incentives to promote the record and recommendations in the playlist and in the search result was the second. Those are contained in separate allegations in the complaint. And the allegation there is that, and so the court asked, so then what is the injury with respect to the bot streaming allegation? What would Drake injuries be? Mr. Gottlieb, the injury in the bot streaming is there is a dilution argument, and there is sort of a streaming to get streaming argument. So the dilution argument is the larger of the number of fake streams that exist in the platform, the lower the royalty rate that goes to artists that are not involved in streaming. The court. So what you're saying is every single artist on Spotify would have this exact same cause of action against UMG? Mr. Gottlieb, yes. And that's entirely consistent with Section 349. In the Northern Autobahn case that we cite in our papers, along with two cases that we cite in our papers in the injury requirement, recognize it that by giving any person is the language of Section 349, by giving any person who is aggrieved by an injury to a consumer standing under Section 349, there is potentially a larger number of businesses, particularly in competitive situations, that can bring claims. But the court has held that those were the intent of Section 349. If you give me a minute, Your Honor, I'll get the case so I can make sure to cite it correctly. The court says, sure. So, Mr. Gottlieb, it's the North Shore Autobahn versus Progressive Insurance case from 2012. And it explains in the section on direct injury how the statute allows for any person to bring a claim. And the question is whether the business that is asserting the claim suffered an injury as a result of the consumer deception. The claim in the North Shore Autobahn case, as well as in the MVB
collision case that we cite was essentially that consumers had been deceived or misled by insurance companies in a scheme to take their business to other businesses that happened to be competitors. And as a result of those consumers being misled to go to other businesses, North Shore Audubon suffered a harm as a result of having fewer, sort of less foot traffic or less traffic into its business. That's essentially the argument that we're making here. When consumers were misled into consumers are misled into listening to a song when they are searching for Drake's music, he is injured by both directly. But then he's also injured as a result of dilution because the less compensation that occurs in the formula from Spotify for its artists. Your Honor, with respect to civil harassment, we can rest on our papers and the authority cited therein unless the court has questions for me. The court, that would be great. Thank you. Mr. Ransom, I'll give a brief period for rebuttal. And so Mr. Ransom is going to rebut. So basically what he's saying is that these bots had inflated the numbers. So with inflating the numbers, Not Like Us showed up on the algorithm at a higher rate. And so if anybody was searching for Drake, they would get Not Like Us. And as I explained earlier, Drake's name is mentioned in the song. So when you type in Drake, let's see what you know what? Ain't no need to do this. I am not I don't think I'm a member of Spotify. So I don't know if that'll come up. Doesn't Spotify, can't you get on Spotify as a, like you do on, what is another platform? Let's see. Let's go to their search. And let's say, so I'm at their search thing. So what should I type in? Should I type in Certified Lover Boy? Or should I just type in Drake? We can do them both. All right. So we got Certified Lover Boy. So the top result is Not Like Us. And then we get down to the artists. We've got SZA and we've got Drake. And then we get to the albums. We've got Certified Lover Boy. And so we do have Drake that's here. There's two tops. But the top result is Not Like Us. And they do the songs. They have Kendrick Lamar, Not Like Us, Certified Lover Boy by Theo. We've got Fair Trade with Travis Scott by Drake and Travis Scott. And then we've got Certified Lover Boy by Sine and S Stone. Okay. Let's type in Drake. Well, that's nothing because I didn't spell his name right. All right. So top results, we get, when I type in Drake, we've got headlines. We've got headlines by Drake. We got Nokia. We got What Did I Miss? We got Passion Fruit. So then we have artists. We have Drake. We have The Weeknd. Look at that. We got The Weeknd showing up. We've got the albums. Which one? If you're reading this, it's too late. What Did I Miss? Some Sexy Songs for You. Take Care. Views. Certified Lover Boy. Her Loss. Then we've got playlists, and most of these are Drake. We've got Rap Caviar. Let's see what else we got. We got podcasts. We've got Drake. He has a podcast. We've got all of these podcasts that come up. We've got episodes that come up featuring Drake. We've got audiobooks, profiles. So we got Young Thug. We got Digits, Forever, Hot. We got Young Thug. We got Future, 21 Savage. We got albums.
We got playlists. So we don't see anywhere on here where typing in Young Thug gets us anything from Kendrick Lamar. And I don't see anything giving us anything with Drake. Let's just do the artist. Let's see how far down that we got to go. I don't even see Drake coming up on this list. He's so far down that it's not. I don't see him or Kendrick coming up on this list as far as with artists are concerned. Okay. So that was just our impromptu research. And so let's do this. Just to be fair, we did Drake's name. Let's do. All right. So we got Not Like Us, All the Stars, Squabble Up. So we have the artist, Kendrick Lamar. You got Taylor Swift that comes up. Kanye, Justin Bieber. We got GNX, Damn, Not Like Us comes up. Pimp to Pimp a Butterfly. We've got these playlists. We've got these podcasts. Let's do like we did before. Let's see the artists that pop up when we say Kendrick Lamar. So we see Kendrick Lamar, and then on the next line, we do see Drake coming up. We see Taylor Swift, Chappell Roan, J. Cole. We see J. Cole before we see Drake. Future and Bad Bunny, Travis Scott, Tyler the Creator. Let's continue. So we did our own little experiment. So if you type in Drake, Not Like Us does come up. All right, let's continue. Because we want to try to finish in the next 30 minutes. Because we've got a long stream. And if you are here and all of you all here, please make sure you hit that thumbs up button or that like or that heart button for me. I really appreciate it. Mr. Ransom, thank you very much, Your Honor. I will endeavor to be brief. I'm sure you will hold me to it. Let me start. If I could, with exhibits B, J, and P to our request for judicial notice. Notice again, are articles that are cited in Drake's complaint. And if I heard Mr. Gottlieb correctly, after discussing them, he said these things in the record. If the court wants to reconsider them, I think that this is a quote we are fine with. So I believe that addresses in large part one of the court's first question as to whether and how it can consider these materials that have been submitted. I believe he said the same as to the song lyrics. When I look, for example, at Exhibit P, and I think about Mr. Gottlieb's characterization of it, I think it also resonates with the court's comment that if the court has these materials in front of it, it can look at them and can look at the entirety of them. So Mr. Gottlieb invoked in Exhibit P the statement, and some of these things have been fact-checked, suggesting that tended to convey a fact, finding of fact versus opinion. That the court said, page 4 of Exhibit P, Mr. Ransom, this is page 4 of Exhibit P. And he quoted solely the portion that some of these things have been fact checked. He failed to read the rest. This illustrates why context is so important.
It says, and some of these things have been fact checked, like Baka Not Nice, who is a rapper in Drake's crew, who was convicted of assaulting a young woman and who was accused of running a prostitution ring. That's the fact check reference. He also overlooks the fact that this article, which they're fine with the court considering, and talking about Drake and talking about the references in Not Like Us, say things like, these are the speaker's quote. We all know the stories of him going to girls' basketball games, and it's in our faces. Let's talk more about these allegations. That's on page 4 and page 5. Let's talk about more of these allegations around Drake. Tihar Haka, as you mentioned, there are some things that we've seen and heard over the years. And then it refers to the discussion or the history with Millie Bobby Brown and her relationship with Drake when she was 13 and he was 30. I'd be darned, or 31. So these articles provide the context that the court can and should consider in our motion to dismiss. So true with respect to the lyrics. And again, the court asked the question about tailor-made's freestyle. And you're right. It is conspicuous that tailor-made freestyle is not included in the footnote in Drake's complaint, but it is referenced in these articles that Drake is fine with the court considering. And there's no real question that it's part of the battle. And again, I think it speaks to the question of context because, yes, I focus on the line, talk about him liking young girls, and that's a gift for me. But from Drake. But the context of that is not even limited to that line. And Your Honor, I'm going to read it verbatim. Please excuse the profanity. This is the entirety of the statement from Drake. Kendrick, we need you, the West Coast savior, engraving your name on some hip hop history. If you deal with this viciously, you seem a little nervous about all the publicity. This Canadian light skin dot. We need a no debated West Coast victory, man. Call him a B for me. Talk about him liking young girls. That's a gift from me. That's the context to which Not Like Us appears. That's the background. That's the history. That's what clearly conveys this rhetorical hyperbole that which you hear in these rap battles is trash talking in the extreme and is not and should be treated as statement of fact. Very briefly, Your Honor, Mr. Gottlieb said that there is no indication of a dispute in Bryan as to the context or the connotation of statements. Bryan is a New York Court of Appeals decision. I am pretty confident that there was a dispute in Bryan. And if the court looks at it, the court reflects that the parties vigorously disputed all issues, but that context was key and that the motion to dismiss was properly granted. Mr. Gottlieb also invokes global networks, which is their brief, albeit not for the point he cites and with good reason. On the pleading standards, motion to dismiss standards, global networks was effectively overruled by Twombly and Iqbal. It doesn't actually state the correct standard. Very briefly on Section 349 claim, I think what the discussion with counsel illustrates is that fundamentally indirect nature of any injury or harm that Drake claims. It requires consumers doing a thing, Spotify doing a thing, royalty streams doing a thing, multiple steps, and that's not what 349 is intended for. It is not intended to permit any person who claims, in this case, as Drake does, that they were effectively, indirectly impacted by some purported consumer deception to bring a claim. That would frankly flood and overwhelm the courts in a way that is unsupported by the courts of appeal requirement, and that the injury both be tangible, non-speculative, and direct. The court, thank you very much. Mr. Ransom, unless the court has the questions, I will rest. The court, thank you very much, counsel, for your arguments today. They were helpful. The court is going to request that the parties order the transcript and split the cost among them. I'm going to reserve decision on the motion to dismiss, so an opinion will ultimately follow. Are there any other issues that the court needs to take up today? Mr. Gottlieb, none for the plaintiff, Your Honor. Mr. Ransom, no, Your Honor. The court, thank you very much. The court is adjourned. So again, this oral argument took place June 30th, 2025. So that was a month and a half ago. So since then, we've had attorneys to withdraw. All right. So we've got all of that done. And we hadn't had anything since then as far as that. So we'll just continue to look and update. All those things are coming. I have it highlighted to look. All right. All right. That is the end of that, y'all. That is the transcript. That is the transcript. What are y'all thinking about that? How do you think the court is going to lean? There's a couple of things that the court said that I was pleased to hear, that she wasn't looking at this thing in isolation. That she definitely wasn't looking at this stuff in isolation. That she was looking at this sorry, y'all. I'm just all right. All right. So the one thing that I'm encouraged, because again, I said in that initial filing, they were acting like that Not Like Us caused all of this kerfuffle over at Drake's house. And then when GMG presented the fact that this is coming from a rap battle, and then their motion to dismiss is coming from a rap battle, then Drake's team decided, okay, we need to go ahead and admit that it was a rap battle. However, they're doing some strange things to get this placed out, and they did all of that. But I am encouraged that the judge, went back and forth with them about, especially Mr. Gottlieb, went back and forth with them about Are y'all trying to make you all are basically, they're trying to make that one song stand out amongst the rest of them, and not look at the fact that Drake and Taylor Made Freestyle said do all of that stuff. And they're trying to make it seem like Drake didn't say anything that wasn't fact checked. And I was so glad that we both came to the conclusion of the argument of two people were battling in the street, and they started saying stuff because they're fussing back and forth at each other. Are people fact checking at that time? No. Who would have known? They're saying, oh, well, everybody, it was ubiquitous at that point. And they shouldn't have been to the Super Bowl. They shouldn't have gone to the Super Bowl and played the thing. And they shouldn't have done it because they knew that after Drake's team sent this information to Spotify, they should have stopped all of their they should have stopped, all the song. They should have gotten rid of the song. Because we asked them in letters and cease and desist for them to stop. But remember, Drake's label is Republic, which is under the umbrella of UMG. And Interscope is Kendrick Lamar's label, which is under the umbrella of UMG. So they operate as separate entities. But they're under, so that, it's just like if UMG was the parent, Republic and Interscope are the children. And they're grown children and they operate accordingly. However, they still are up under the tutelage of the parent company, which is UMG. So, y'all, when I tell you this is a mess, I will tell you this is a mess. This is a mess. But I am assuming that the judge any day now will come out with a verdict of whether or not that they're going to dismiss the case. In the meantime, she did say that it was okay for them to do discovery, to continue discovery, and to get that information in. So she's okay with that for now, because again, I don't know how encouraging is that, meaning that we're going to go to court or not. I am not sure. In my opinion, I think that we'll possibly go to court. I think that we'll possibly go to court. But we'll see. Because again, she's got to go through that. She's going to have to go through the whole rap battle, y'all. She's going to have to go through that whole rap battle. And depending on where she starts, does she start with first person shooter? Or does she start with push-ups? All of this is going to be interesting. All right, people. I ain't gonna keep y'all no further. I do appreciate all of you all that have been sitting here listening to me. I really do appreciate it. And again, make sure you hit that like button. If you're following me on Twitter, please consider joining me over on YouTube. I really would appreciate it. Y'all, please like, comment, and subscribe. Please share this video if you care. Please tell a friend, tell a kin, tell a coworker, tell that heifer that you can't stand that I'm over here making these videos. And as always, people, y'all have a good rest of your day. And bye-bye.